All right, we are gathering back here. This is the Colorado Energy Carbon and Management Commission, and it is January 24th, 12:35. We will continue with docket 230900287. This is an extraction resources request for approval of pending Form 2s for the Coyote Trails location. At this time on my agenda, it says there is a presentation by CDPHE. Hello, Ms. Sorensen. Hello, Commissioner Oath. I assume Ms. Sorensen is going to be doing a presentation?
Yes, Mr. Chair, that is our plan. Thank you.
Great. And Ms. Sorensen, I'm going to be listening intently, but I was able to obtain my lunch and not eat it. So I'm going to unvisualize for the next few minutes so that I can eat a little bit and not distract from your presentation.
Thank you, Mr. Chair. Can you hear me okay?
We can.
Okay. Let's share my screen then. All right, you should be seeing it in presentation mode.
Yes, we are.
Excellent. Okay. All right, my name is Tessa Sorensen. I'm the energy liaison for this Colorado Department of Public Health and Environment. I use she, her pronouns. This is in relation to the Coyote Trails docket we've been hearing about. To give you a short timeline before I go through my brief slides, on November 13th of last year, the commissioners actually requested that CDPHE perform a consultation on this site. That was me doing that. We actually contacted the relevant local government designees. A meeting was held with the town of Erie and Broomfield County on November 17th of 2023. Broomfield was in attendance as an observer, and Boulder County was there, but in attendance as an observer. The consultation meeting also took place on November 17th between CDPHE as well as representatives from the Location Assessment Group in ECMC and Civitas, the extraction parent company, to discuss it. And then a follow-up meeting with Weld County was held on November 21st of 2023. Okay. So you'll recognize the photo. This is actually the same picture David Frank was utilizing up there. Appreciation to him for getting us a picture here. This location is in Weld County. It is next to Broomfield County and the town of Erie. There are 27 wells in existence here. There are 18 additional wells proposed. It is next to the Front Range landfill. That is that big hill you see under the green arrow there. That landfill itself actually processes drilling cuttings regularly on a daily basis from the entire area, not just this pad at all. This is taken from the corner of Weld County 4 and Sheridan Parkway. It can actually be kind of a rough corner on occasion for traffic. But you can see in that red box there, that is the location that you can see itself. And these homes that this picture is taken from are actually the homes located in Erie. Okay, so let's look at this on the map. This is a very complicated jurisdictional area here. The red star is the location of that particular pad. You'll see that Broomfield County is to the east, and this road system here is actually the new homes that have been built since the initial occupation of that site. And down here is the houses in Erie. This is the landfill complex up here that is next to it. And you can see Broomfield, or Boulder County, excuse me, is to the west. Just south of this line is actually Broomfield County as well. And the rest of this is up in Weld County. The town of Erie has a very kind of unique shape here. You'll notice there is a big cutout around the western part of that landfill that you can see there that is actually in Weld County, but throughout here, this is actually the town of Erie itself and borders directly next to that location, which is not itself in the town of Erie. It is actually in unincorporated Weld County. All right, so let's talk about what's actually around this location. By exact count, and at these numbers, it's actually difficult to get an exact count. There are, I think the official count from ECMC staff is 186 residential building units within 2,000 feet. That orange circle, you've seen this before. This is done through cooperation with our local government. partners here. Out of that 186, there are about 90 that are in Erie and about 80 that are in Broomfield and about 16 or so that are actually in just Weld County. Within 1 mile, there are 5 high occupancy building units. There is an elementary school, 2 other schools, a preschool that is part of a church, as well as a senior assisted senior assisted living facility. I believe that's a typo in there. And then just outside that 1 mile radius is actually the Children's Hospital Colorado North Campus. There are 2 parks within 2,000 feet of this working pad surface and about 10 within a mile. Let's talk about the demographics here now. This is not in a statutorily defined disproportionately impacted community. It is in the ozone non-attainment area under the severe classification. It is not in a cumulatively impacted community, which is a subset definition of the disproportionately impacted community. There's some interesting census block group data here. Now, I do want to make note, these demographics are limited by census block group granularity. This outline is how big that census block group is. So you could see that that's a very large area. And so you cannot say that one small location within that area will have this percentage of population qualifying for these demographics, but it does give you a good approximation. In this census block group, you're in the 84th percentile for population under 5 years of age, and the 86th percentile for cancer prevalence in adults. So a lot of children and a lot of health issues in that census block group compared to the rest of the state. Some history on this location. In 2017, it was approved by COGCC. In 2018, 10 wells were drilled. In 2019, an additional 17 wells were drilled. In both of those drilling segments, it was performed with drilling rigs that operated on Tier 2 diesel engines. This information, by the way, comes from Civitas, Extraction's parent company. They utilized hydraulic fracturing rigs that were actually Tier 2 diesel engines as well. For those of you not in the know of what the Tier 2 means, that's actually a higher emission than say Tier 4 diesel engines or natural gas reciprocating engines. So these are higher emissions than are preferred now, but they are actually allowed under regulation, absolutely. They utilized IOGP Group 1 drilling fluids used. These are basically diesel-based fluids with a very high aromatic content. There would be noticeable odors coming off a pad that utilized IOGP Group 1 drilling fluids. There were 10 tanks installed on the pad and 1 maintenance tank. In this picture, which is an old picture, it is currently on satellite photo, but this is not the current state of the pad. You could see those 10 tanks right here. There was no instrument air on site at that point, which means that the controllers were all powered by natural gas and could potentially also emit. There were numerous local complaints during these times for odor, noise, and light. Most of them were local. Some of them did actually make it to the state level. The site was inspected more than once by the state representatives, either from APCD or ECMC. There were no notices of alleged violation issued by COGCC from that time period. Since then, there have been existing improvements done to this site. You'll notice the tanks are gone. I'm going to flip back and forth a couple of times to illustrate that. You'll see the tanks here on the south side of the pad, and they are now gone. All those storage tanks have been removed. The instrument air has been installed, so there are no longer any risk of emitting pneumatic controllers. They do plan additional improvements to this site, according to Civitas, including replacing their maintenance tank with a maintenance vessel, which has less risk of emissions. Upgrading their access road from dirt gravel to a recycled asphalt, but that would be post-completion activities if they were allowed to do so, as well as a potential to replace the entire pad site surface with recycled asphalt. Their proposed operations for this drilling cycle is actually significantly improved from their prior. They would be utilizing completely grid-powered drilling electrification. So they would be using drilling rigs that run on grid power. Their completions and fracking would run off of a Tier 4 quiet frac fleet. So that is less noise and significantly less emissions. They would be utilizing Group 3 drilling fluids. So a lot less aromatics. To compare what Group 1 versus Group 3 drilling fluids are, an IOGP Group 1 drilling fluid is greater than 10%, usually polycyclic aromatic hydrocarbons, which are known to contain carcinogens. They are also very strong odor and aromatics. IOGP Group 3, compared to that 10 weight percent, are actually 0.001 weight percent or less of those same aromatics. They also have planned operational considerations for any operations done on forecasted high ozone days. So let's do a summary here of what I've just described to you. That's a lot of data and a lot of facts. Local industry. There is a landfill that regularly processes cuttings nearby. About 2 miles west of this site is the Erie Municipal Airport. So there's a fair amount of noise pollution with that as well. I cannot speak on the actual emissions from the airport. I'm not sure that's valid for this. In terms of emissions, the planned operations they are proposing for this particular drilling occupation are roughly half or less what was there in the initial occupation. The truck routes they're proposing are to the east of the pad going north and avoid most of the population, but any population they would affect the most would likely be the Broomfield population. The residents in this area have significant numbers of residential building units with a large number of therefore possibly impacted population. This population does contain a lot of the elderly as well as children and school children. And with that, I am open to any questions.
Great. If you want to stop the screen share, then commissioners have an opportunity for questions. I just want to signal appreciation to CDPHE and to you, Ms. Sorensen, for the work that you've done here. I understand that this is, again, sort of not typical, and at our request, you really did a yeoman's job of getting the CDPHE consult done in a quick turnaround. And so we really appreciated that. It adds a lot of value to our consideration on this matter. I'm not seeing any questions, so you did an outstanding job of summarizing your findings. So thank you very much. If you could.
Thank you, Mr. Chair. Thank you, commissioners.
Maybe stick around if we have any further questions later on, that would be great.
I will be here.
Awesome. Okay. All right. Moving right along, we now have a presentation by Extraction. Good afternoon, Mr. Prashala.
Good afternoon. I'm just confirming that all of my folks are elevated to panelists. The only person that I do not see on here is Kathy Stearman. She's available for questions, but in the interest of time later on, to the extent that she is asked for questions, I think it probably would be helpful to have her elevated now as a panelist.
Why don't we go ahead and have your witnesses visualize themselves, and we can have AG Davenport swear them in.
Mr. Prashala, is everyone, as far as you can tell, visualized now?
I believe I see everyone, yes.
Okay, thanks very much. To the witnesses, I'm going to ask you to raise your hand in turn, state your name, and state that you swear to tell the truth. I'll call your name in turn based on the order that I see you in my screen. Mr. Newhall, would you go first?
Good afternoon. My name is Chandler Newhall. I swear to tell the truth.
Thank you. Mr. Annabelle?
My name is Jeff Annable, and I swear to tell the truth.
Thank you, Mr. Bennett.
Good afternoon. My name is Nathan Bennett. I swear to tell the truth.
Thank you, Mr. Casper.
My name is Sean Casper, and I swear to tell the truth.
Thank you. Mr. Schleba?
My name is Aaron Slaba, and I swear to tell the truth.
I apologize for the mispronunciation.
No problem.
And finally, Ms. Stearman.
My name is Kathy Stearman, and I swear to tell the truth.
Thank you. I do see Mr. Flanagan. Mr. Prashala, should I? Okay. Mr.
Yes,
Flanagan, please go ahead.
My name is Sean Flanagan, and I swear to tell the truth.
Thank you. Did I miss anybody, Mr. Pashal?
I believe that is everyone. Thank you.
Thank you.
All right, the floor is yours, Mr. Priscilla.
Thank you. Good afternoon, Chair Robbins and Commissioners. As you know, my name is Joe Pershala with Wellborn, Sullivan, Meck, and Tooley, and I am here today on behalf of Extraction Oil and Gas. I believe there was it was misnamed in the agenda as Extraction Resources, so just want to clarify that for the record. With me today and presenting for Extraction are Chandler Newhall, Asset Development Manager, Jeff Annable, Manager of Well and Location Permitting, and Aaron Schlabaugh, Senior Air Monitoring Specialist. Also available for questions are Kathy Stearman with respect to air, Sean Casper with regard to surface land, Sean Flanagan as it respects mineral land, and Nathan Bennett as it respects permitting and compliance. On behalf of Extraction, I would like to thank staff and Ms. Sorensen of CDPHE for all of their time and efforts spent working with Extraction on the Coyote Trails APDs. I would also like to thank Ms. Teeters for her time and comments and support on behalf of Weld County. Extraction appreciates your continued participation, your insight, and your cooperation on its projects. Now, this is a novel hearing on two fronts, really. It is the first time that the Commission has moved under Rule 503A to assume review authority from the Director for a Form 2A application for permit to drill. It is also the first time that the Commission has independently reviewed a Form 2 application for permit to drill. Given that novelty, it seems a logical starting point to consider what is the framework and the standard that the Commission will review the 7 Coyote Trails APDs before you today. I'd first like to address whether an oil and gas development plan application under Rule 304 would even apply. Pursuant to Rule 303A, an oil and gas development plan application is required if the subject oil and gas location, in this case, the Coyote Trails pad, location ID 319094, meets the criteria of Rule 304A, which are surface disturbance at a site previously undisturbed by oil and gas operations, surface disturbance for purposes of expanding an existing working pad surface, or any significant change to the design and operation of an oil and gas location, such as adding a well or pit that was not previously included on the original Form 2A. None of the Rule 304A criteria apply to the Coyote Trails pad. This pad is an existing oil and gas location. The Form 2A was approved for a total of 45 wells, 27 of which have been drilled, which includes the Coyote Trails APDs, not in the category that have been drilled, but in the total count. The original disturbed area approved by the Form 2A will not be expanded, and there will not be a significant change to the design or operation of the location as approved by the Form 2A in order to accommodate the Coyote Trails APDs. In fact, the Form 4 sundry, which Extraction is prepared to submit with enhanced best management practices for the drilling of the Coyote Trails APDs, will actually result in less equipment improvements, and will take full advantage of the already electrified location that was converted in 2022 to a fully tankless facility. Further support that neither a new Form 2A nor OGDP application is required can be found in Rule 308A, which provides that if, quote, if the operator's Form 2A and drilling and spacing unit, where applicable, were approved prior to the effective date of this rule, then the operator will submit and obtain the director's approval of a complete Form 2 application for permit to drill, close quote, before commencing well operations such as drilling or re-entering the well. Here, the Form 2A for the Coyote Trails pad was approved on November 20th, 2017, and the spacing unit for the Coyote Trails APDs was approved on July 31st, 2019 by order numbers 407-2870 and 407-2871. Thus, neither a Form 2A nor OGDP application are required, and Extraction has properly submitted the Coyote Trails APDs to the Director for review and approval. Moreover, the ECMC permitting scenarios operator training dated January 14th, 2021, revised February 15th, 2021, under Scenario 6, further confirms that under these circumstances, neither a Form 2A nor an OGDP application is needed. I'd like to now turn to the standard of review that governs the review and approval for the Coyote Trails APDs. In 2021, as part of the mission change 200, 600 series rulemaking, the Commission adopted Rule 308, which provides the framework for Form 2 APD submission, including the materials and informational requirements. It provides for the administrative review process. It provides the standards for such review. Rule 308C1 provides the governing standard of review, which is the director may approve a Form 2 that complies with all requirements of the Commission rules and protects and minimizes adverse impacts to public health, safety and welfare, the environment, and wildlife resources. In conducting the Form 2 APD review, Rule 308C1A authorizes the director to add any conditions of approval that the director determines are reasonable and necessary to ensure compliance with the Commission rules and to protect and minimize adverse impacts to public health, safety and welfare, the environment, and wildlife resources. In addition to the Form 2 review, Rule 308C1B requires the director to also review the associated oil and gas location, in this case, the Coyote Trails pad, to ensure that reasonable and necessary conditions of approval are applied to protect and minimize adverse impacts to public health, safety and welfare, the environment, and wildlife resources. Now, these are the standards by which the Coyote Trails APDs are to be reviewed here today. I do note that there may be other more general standards of review within Commission rules governing the broad scope of oil and gas operations, as that term is defined, such as Rule 301A. But because Rule 308 is specific to Form 2 APDs and provides a specific standard of review, Rule 308 controls over any other general provisions. And I cite to you Martin versus People, 27 Pacific 3rd, 846 at 852, Colorado Supreme Court, 2001, en banc, holding that where two statutory provisions cover the same subject area, the specific provision prevails over a more general provision because the reverse would render the specific provision ineffective. With the standard review having been provided, I'd like to also turn to public comment. The review of the Coyote Trails APDs and determination thereon must be insulated from public comment. When the Commission adopted Rule 308, it directly considered whether public comment should be a part of the APD review process. In the statement of basis and purpose for the mission change 200 to 600 series rulemaking, the comment to Rule 308C provides, quote, unlike oil and gas development plans, the Commission determined that Form 2s should be subject to administrative review and approval by the director rather than review by the Commission. Close quote. The comment continues that the staff's review should be insulated from, quote, outside concerns, close quote. The prohibition on outside concerns influencing the Form 2 APD review process includes public comment. The statement of basis purpose comment states, quote, some stakeholders also suggested that Form 2s be subject to a formal public comment process akin to the process for public review and comment on an oil and gas development plan. For the reasons explained above, the director determined that public comment on a Form 2 is unnecessary and that decisions about Form 2s should be left to the Commission's expert staff, close quote. With the standard of review established, I would like to now provide a brief summary of the Coyote Trails PAD and the Coyote Trails APDs. The Coyote Trails PAD was approved in 2017 and upgraded in 2022. It was the result of extensive collaboration with all stakeholders, that being Weld County, the Town of Erie, City and County of Broomfield, Commission staff, and community members. The location is uniquely situated within the Front Range landfill that provides topographical features that isolate the pad from many of the surrounding RVUs and provide natural mitigation of noise, light, and visual impacts to the surrounding community. The location currently has 48 best management practices applied to the Form 2A, covering all aspects of operations, including community outreach, noise mitigation, emissions mitigation, odor, traffic, and 2 conditions of approval, one of which is noted in the director's summary regarding water sampling. As will be further discussed, Extraction intends to add to these best management practices as part of the Coyote Trails APD approval. But before getting to those practices, I'd like to briefly touch on some of the stakeholder involvement in the development of the Coyote Trails pad. While this pad is located in unincorporated Weld County, as part of the WOGLA process, the town of Erie was invited to and did participate in that process. Through that involvement, Extraction heard Erie's concerns and agreed to many of Erie's requested best management practices. That includes sighting distance to Erie RBUs of not less than 1,000 feet, lighting and noise mitigation, use of an oil gathering system, traffic and haul routes, use of closed loop systems, specifications for drilling and hydraulic fracturing fluid, and later rerouting the haul route for drill cuttings from entirely within the landfill property for disposal, and instead going to the east onto County Road 7, traveling north around the landfill to the disposal site. With respect to the city and county of Broomfield, Extraction in the city and county of Broomfield developed an operator agreement to govern Extraction's operations within Broomfield's jurisdiction, but that operator agreement also affected the Coyote Trails pad. For example, as part of the agreement, Extraction agreed to move 40 wells, including the Coyote Trails APDs, from locations in Broomfield to the Coyote Trails pad. And the operator agreement also informed other aspects of the Coyote Trails pad that include an extensive legacy well P&A program, 3-phase pipeline takeaway, and facility design that was upgraded in 2022 to the same design standards as the locations in Broomfield. And Extraction's work with the city and county of Broomfield has continued through to the Coyote Trails pad and the APDs, as evidenced by an agreed upon air monitoring plan that includes a sensor to be located on the east side of County Road 7, nearest the RBUs within Broomfield's jurisdiction. The development of the Coyote Trails pad is demonstrative of Extraction's willingness to meaningfully engage with local governments and state agencies on all facets of development, to listen to the concerns and reasonably modify its plans in response thereto, and its commitment to continuously deploy all best available technologies. Now, as Extraction is moving to complete its development phase on the Coyote Trails pad with a single final occupation, Extraction seeks to enhance this location for the drilling of the Coyote Trails APDs with additional best management practices that it is confident will further ensure the continued minimization of adverse impacts and the protection of public health, safety, and welfare of the environment and wildlife resources. Some of those best management practices include an enhanced community outreach program, providing a 30-day pre-construction notice, as well as a move-in rig-up notice to all owners and residents within a half a mile of the location. In addition, there will be a website, which is live as of today, with information on all aspects of the development, including a timeline and informational resources. Extraction will utilize a Highline electric-powered drilling rig, Group 3 drilling mud, Tier 4 equivalent or better completions fleet and a quiet frac fleet, next generation flowback system, as I mentioned, a fully tankless facility, a continuous air monitoring system, and incorporation of all of the CDPHE recommended best management practices. As you will hear, Extraction's data estimates show that these enhanced best management practices will substantially reduce VOC and NOx emissions as compared with the prior operations on the location. These enhanced best management practices, combined with the existing operational protections, represent a state-of-the-art oil and gas location that prioritizes and will demonstrably mitigate adverse impacts and will protect public health, safety, and welfare, the environment, and wildlife resources. Extraction respectfully requests that the Commission approve the Coyote Trails APDs and include the enhanced best management practices as proposed by Extraction as reasonable and necessary conditions of approval. Thank you. And with that, I'm going to turn the presentation to Mr. Newhall. If you would just give me one moment to load the PowerPoint. Can you all see the PowerPoint?
Yes.
Excellent, thank you. All right, and with that, I would turn it to Mr. Newhall.
Yes, good afternoon. My name is Chandler Newhall, the Asset Development Manager with Civitas. Joe, if you would go to slide 2, please. Today, I'll be providing some history and background on the location, I have Jeff Annabelle. He's our manager of well and location permitting. He'll present on BMPs, and Aaron Schlabot, senior air monitoring specialist. He'll be talking about the air mitigations and plans we have at the Coyote Trails pad. We also have other individuals available for questions as well. You would please go to the second slide. Third slide. First, I just want to again thank you for the opportunity to present and discuss matters related to Coyote Trails. I'd like to begin with an orientation on the location of the site. The Coyote Trails pad is in Weld County in the southwest part of Section 28, 1 North, 68 West, within the landfill. The nearby crossroads are County Road 7 to the east and County Road 6 to the north. And as discussed earlier, the relative local government is Weld County, where we have an active permit, WOGLA 17-0074. There are a total of 18 remaining well slots at this location. Additionally, there are no schools, child care centers, high occupancy building units, designated outdoor activity areas, floodplains, public water systems, or riparian corridors within 2,000 feet of this pad. The nearest residential building unit is roughly 1,400 feet away from the proposed wells, while the working pad surface is just outside of 1,000 feet. There are no disproportionately impacted communities within 2 miles, and the pad is not within any high priority habitat. You can see here in the map where we have 16 producing wells in the South DSU, 11 in the West DSU, 7 pending APDs in the North approved DSU, and a proposed West DSU with 11 APDs. Next slide, please. Here, I'd like to provide a brief overview of the project history. Again, the Coyote Trails originated in 2017 when there was an effort to adjust and shift wells in the Broomfield project area. Ultimately, 40 wells would be shifted from Broomfield to Coyote Trails. The Form 2A was approved for 45 wells in November 2017, followed up with us permitting and spudding the initial 10 wells in February of 2018. And then the following year, in 2019, we drilled another 17 wells and brought them on production of October of that year. During this time period, between 2017 through 2021, we continued to remove 28 legacy wells and related production facilities, reclaiming and restoring those locations. Then, January 2022, another 7 APDs were submitted for the North approved DSU. At this point, we had discussions with ECMC staff about the other remaining 11 well slots and concluded that a final occupation plan would be best. After conclusion of this hearing and the pending West DSU hearing, our plan is to submit the remaining 11 APDs to support our final occupation of the development phase, which would be scheduled to spud later this year with all the wells on production by around August of next year. At that point, the remaining legacy wells would be plugged and abandoned. Next slide, please. The duration of the final occupation is estimated to take around 11 months. If approved, it would be a slight extension of the pad, and that would start in the 4th quarter of 2024, which is just the area on the northeast edge of the pad to accommodate the MLVTs. The drilling phase is anticipated to commence this fall, around October, with a duration of about 4 months. At that point, the completion phase would begin around the 2nd quarter of 2025, with another 4 months, and lastly, interim reclamation and plug and abandonment of the remaining legacy wells. Here is a current image of the Coyote Trails pad looking towards the northwest. The remaining well slots are depicted with the green dots in the north row. The facility equipment was upgraded in 2022 to a fully tankless system with removal of remaining tanks and installation of a maintenance vessel. The additional separators would be added along the area to support the new wells. They're shown by the separators with the green slashes. Operations at Coyote Trails would utilize existing best management practices that are already established, such as electrical infrastructure for the drilling phase and for the production facility equipment, along with the operational oil, gas, and produced water pipeline gathering systems. Next slide, please. I'd like to talk a little bit about the plug and abandonment program. The Coyote Trails Development Project enabled the plug and abandonment of 29 original legacy wells. To date, total of 28 of those wells have been plugged and abandoned, tanks and facility equipment removed, and sites restored. 10 of those wells were here in the South DSU towards Broomfield. 4 wells in the Western DSU area, and 12 wells in the North DSU of Section 28, where we plan to drill the 7 new wells. The last remaining original well in the project area is the Young 4-31. However, 2 additional legacy wells will be added, the Arapahoe 1-36 and the Arapahoe 36-3 with the new Coyote West DSU, bringing the total count of legacy wells removed to 31. Next slide, please. Like all the other sites, the remaining site here's an example of what equipment gets removed. This site, the Young MC 4-31, was included in the Broomfield Operator Agreement obligation. The well is located in the city limits of the town of Erie, adjacent to County Line Road. As you can see in this image, the facility location, access road, and well location will be removed and reclaimed, with the plug and abandonment of this well. Also includes removal of the 2 oil tanks, water vault, separator, and gas meter house, along with decommissioning of the flow line. At this point, I'll turn it over to Jeff Annable, Manager of Well and Location Permitting, to further expand on the best management practices.
Thank you, Chandler, and good afternoon, Commissioners. My name is Jeff Annable, Manager, Well and Location Permitting for Civitas Resources. This slide highlights the industry-leading best management practices that will be added to reduce impacts during the final occupation that I will cover in subsequent slides. Next slide. First, I would like to cover our community outreach and wildlife BMPs. Extraction intends to go above and beyond the mandatory move-in rig-up notice and send a voluntary pre-construction notice that meets ECMC standards to all owners and tenants within half-mile radius of the planned working pad surface. Both of these notices go above and beyond the 2,000-foot buffer required by the rules. The notice will include a link to a website dedicated to this project where you can find project timelines, best management practices, and a tool to submit comments. Furthermore, we will conduct an avian survey before starting construction to confirm any conflicts, that we will avoid any conflicts. Next slide. Next, I would like to cover some BMP additions that will be implemented during the construction phase. In order to minimize dust emissions during pre-production operations, we will utilize fresh water on exposed earth surfaces during high wind days, continually inspect and maintain the integrity of the access road, and install and maintain vehicle tracking controls to further reduce mud and dirt from being tracked on the public roadway. Next slide. Now I'd like to cover some pre-production operation BMPs that will be implemented as a part of this final occupation. In an effort to minimize potential odor impacts, extraction will utilize Group 3 drilling mud, remove drill cuttings daily, and perform a pipe cleaning procedure when drill pipe is removed from the hole. Additionally, it is worth mentioning that consistent with our previous occupations, we'll be using an electrified drilling rig to minimize emissions and noise during this phase. I would like to apologize for the miscommunication with CDPHE during our consultation. We did use an electric drilling rig during the original occupations. During the completions operations, we will be using Tier 4 equivalent or better quiet completion fleet, and we will be sourcing the water using temporary above ground lay flat water lines. Next slide. In order to mitigate noise during pre-production operations, we will install a 32-foot sound wall on the southern and western sides of the pad. These sound walls, in combination with the landfill berm that you see in the picture, and the utility power drilling rig and the quiet completion fleet should greatly minimize potential impacts during drilling and completions operations. But to ensure we are mitigating noise in compliance with ECMC rules, we will install 4 continuous noise monitors. I would like to conclude the pre-production operations section by noting, excluding the temporary freshwater storage area, Extraction has estimated that approximately 85 RBU owners will be within 2,000 feet of the proposed pre-production equipment, none of which include the homes within the city and county of Broomfield. Next slide. Finally, I'd like to cover production operations at the Coyote Trails pad location. We have improved the existing facility and planned facilities to use compressed air pneumatics and a pressurized maintenance vessel that all but eliminate venting during normal and maintenance operations. This location was approved to have 10 oil tanks and 4 produced water tanks, all of which have been removed and will not be replaced. We will also work with CDPHE to conduct continuous air monitoring, which we will explain more in the following slides. Besides these new measures, I also want to mention that this location already has oil, gas, and produced water pipelines, so traffic during the production phase will be minimal. We have also committed to CDPHE ozone mitigation BMPs listed on the slide before you. And to conclude the production operation slide, it is worth noting that approximately 100 RBU owners will be within 2,000 feet of the existing and proposed production equipment and wells, again, none of which are located within the city and county of Broomfield. I hope the slides that I have presented regarding our best management practices have demonstrated that we have spared no effort or resource in committing to the gold standard development for the final occupation of our full development phase. I would now like to pass the presentation over to Aaron to discuss our air monitoring plans. Thank you, commissioners.
Thank you, Jeff, and thank you, commissioners. I'd like to take this opportunity to discuss the overview of our ambient monitoring program at this pad. We are proposing to place 3 ambient air monitors around the perimeter of the pad and 1 additional community-based monitor to the east of the pad. We will work with Broomfield to determine an appropriate location of the community-based monitor. Each monitor will be able to monitor in near real time total VOCs, PM, meteorological conditions, and also have the ability to take full air samples that can be sent to a laboratory for speciation analysis. Since the first phase of development for this pad, improvements have allowed us to reduce VOCs by 87% and NOx by 33% per well. Next slide, please. Additionally, we currently have a continuous OGI monitor at this facility. It's mounted on an open lattice tower in a central location of the facility, and it looks at 25 different zones within the facility for approximately 2 minutes per zone, completing a full rotation around the facility approximately every hour. We plan to continue using the system for the life of the wells, and it allows us to quickly identify any potential leaks. Thank you. That's concludes my discussion.
Thank you, Mr. Schlaba. Thank you, Mr. Annabelle and Mr. Newhall for your presentation. I would just like to provide the commission some conclusory remarks. And note that first, Extraction recognizes the importance of its role as a partner in the communities that it's operating, and that it is committed to working with, hearing, and being responsive to the concerns of all of its stakeholders. It takes those concerns seriously whenever possible. Extraction has attempted to meet those concerns with reasonable measures to mitigate and minimize impacts of its operations. Indeed, Extraction did not hesitate in committing the staff to one final occupation to complete its development phase of the Coyote Trails pad. To briefly recap, Information is critical to community members. Extraction is committed to a robust community outreach program, providing a website with continuously updated information so that the community members can regularly inform themselves of the operations at the Coyote Trails pad. Extraction will provide a 30-day pre-construction notice and move-in rig-up notice to all owners and residents within a half a mile of the pad, informing them of the planned operations and all of the information required by Rule 412B. With respect to noise, odor, and traffic, as you've heard, Extraction will further mitigate noise and odor by using line-powered electric drilling rig, sound walls and traffic control measures, Group 3 drilling mud, 3-phase pipeline takeaway, and a completely tankless facility design. With regard to air, Extraction will further mitigate its air impacts and decrease VOC emissions by 87% and NOx emissions by 33% per well by employing these facility improvements and best management practices, including Tier 4 equivalent or better completions fleet, Group 3 drilling mud, and next generation flowback design, all of the CDPHE recommended best management practices, and the deployment of the continuous air monitoring program with continuous leak detection. Importantly, there have not been any NOAVs issued related to the Coyote Trails pad during the drilling and completion phases or as a result of any complaints with the prior operations. With that, Extraction respectfully requests that the Commission approve the Coyote Trails APDs, apply the enhanced best management practices as reasonable and necessary conditions of approval to minimize the adverse impacts associated with the Coyote Trails APDs. Thank you.
Okay, if we could stop the screen share. All right, Mr. Pichelle, I'll just start out. If Extraction is so desirous of ensuring that it meets the concerns of all stakeholders, why on earth did Extraction not reach out to the town of Erie or the city and county of Broomfield when it filed for these APDs?
Well, I will let Mr. Bennett speak to that in more detail, but I think one thing that is important to note is that there have been ongoing conversations between Erie and Broomfield for many years related to the operations in this area, that both entities have been fully informed as to Extraction's operation plans, current and future. But I think there is a difficulty in providing information with respect to APDs that were not even approved at the time. You know, without certainty, it's difficult to communicate beyond just an intent, but I'll let Mr. Bennett speak to that further.
Well, and Mr. Bennett, before you answer, I do think you can hide behind the technicality of the rule that you didn't have to provide notice when you filed the APDs, but that doesn't get around the fact that these communities who are very near to your location have expressed concerns since 2017, and so I'm looking for a hearty answer here.
Good afternoon, Chair Robbins, and thank you for the question. I do appreciate it, and I certainly understand where you're coming from. As Mr. Pershala referenced, Extraction through Civitas has had ongoing discussions with both the town of Erie and the city and county of Broomfield as it relates to operations in this general area. Part of those discussions include at times confidential information shared about future development plans and what options may exist for those development plans. That said, for an administrative process, to your point, we have found in our experience that it's often difficult to talk about possibilities with interested parties when there's no tangible evidence, if you will, to base your go-forward plan on. Right or wrong, again, we found that when we have an approved permit, we're better able to understand and incorporate, more importantly, any changes or BMPs that we can to appease those local stakeholders, deliver them a finite timeline as to what our development operations may look like, and then more importantly, figure out how best to continue that communication point forward during that operational phase so that we can address their comments as they occur in real time.
Oh, I appreciate that, Mr. Bennett, and I have enjoyed, good working relationship with this company and with yourself. I don't know that hiding behind confidential business information really works when it's an actual publicly filed document, as an APD was filed here. And it's just disheartening to me that the communities only learned of this because of their own snooping in our system without getting affirmative upfront talking with the company to the communities. I got a couple other questions.
Mr. Chair, just on that point, if you provide Mr. Bennett with an opportunity to respond on the
Sure,
comment that
go for it.
local government had no idea that this was coming.
Yeah, to be able to clarify my comment as it relates to confidential information, it was not to infer that the 7 APDs at issue here were, quote, confidential, but more importantly, potential future development opportunities in and around these communities that does or did at the time contain confidential information as it related to, material go forward opportunities for the company.
Okay, thank you. Did you have anything further on that topic? I'm going to switch gears here.
No, sir. Thank you.
Okay. I'm not sure who the witness was, but someone spoke to a slight expansion of the pad. I'd like to hear more about that, and we can bring that slide back up. Is the expansion redisturbing areas of the pad that are part of the 2A, or is an expansion beyond the originally approved 2A?
Great question. Joe, if you could go back to that slide, I could point out, have you point out.
Give me 1 second here.
But it is part of the original Form 2A. And it was the area that would host the MLBTs. And it was reclaimed, and then that area would be just pushed out. So go to the next slide, please. The next one.
Yeah, that
Right.
one.
Yeah, so right there, just on the eastern slide edge, is where the MLBTs originally were. And so that area would get just pushed back out to support during the frac phase. And then when we're done, that area will be pushed back. So it's all within what was planned and anticipated on the Form 2A.
So it's not expanding the size of the pad, it's just moving things around.
That's correct.
Okay. Can someone, and you can drop the screen share, can someone provide us with some perspective? We heard from folks within the communities that, they had presumed that this was going to be 2 phases of drilling, and that, the preliminary one and then the second one. And we heard from some of the witnesses that after about 2019, 2020, all the assumption is that there wasn't going to be any additional drilling out there. Can someone from the company speak to, how it is that you didn't do what you initially indicated you were going to do in terms of the Form 2As, and why?
Thank you for the question, Chair Robbins. I may start the discussion and then turn it to Mr. Newhall for some additional information. I do think there's an important differentiation between some of the terms that were used today, and you did get it right when you used the term phase, quote unquote, rather than, quote, occupation, end quote. And so you are correct. Our plans clearly indicated that we had intention for 2 phases, an appraisal phase and a development phase. The APDs pending before you and the additional DSU that's pending before the commission in a couple of weeks are the final elements in that development phase. To the best of my knowledge, recollection, and understanding, the company never communicated that, quote, we were done, end quote, regardless of any time that may have elapsed between the appraisal phase and the initiation of the development phase. I'll turn it again to Mr. Chandler Newhall if he has anything additional to add.
Yeah, and during this time period, we had other legacy obligations that we were needed to remove. I routinely had discussion with the city of Broomfield as it relates to timing of our obligation to remove legacy wells related to the operator agreement. The Young 4-31 is in that operator agreement, and We continued to communicate to them that we were working on plans to try to how to develop that area to remove that well. We'd been into conversations, we'd been meeting regularly with the town of Erie, with David Frank, just on our development plans along this area. So there's been quite a bit of discussion just how we can develop this area, remove legacy wells, and what pads might we take those from.
Okay, Commissioner McGowan?
Thank you, Mr. Chair, and thank you for opening up this. I had some similar questions. I guess I would like to, so in your discussions of, potential development and removal of wells, did you specifically discuss, we're not done with the final phases of the Coyote Trail site, and there will be more drilling there with these two jurisdictions?
We did have discussions through the last couple of years about that, including, where would we drill locations from? We had conversations about possible sites inside the town of Erie. And would those be drilled in the town of Erie, or would they actually be drilled from Coyote Trails pad? Given that Coyote's Trail pad has already existing infrastructure there, oil, gas, water takeaway capabilities, the site's already built. All the other BMPs that we got at this location, electrical infrastructure, the Coyote Trails seem to be the least impactful location to where we could remove legacy wells and develop the new wells.
Can you see how or why folks who read the language in the WOGLA documents and in the Form 2As would be under the impression that if the phase 2, it was your second occupation and that was it? I mean, to their point, right? You've done interim reclamation. It feels like that would be it. And the language, if I were to read it as a lay person, seems like, well, that was it. They did 1 and they did 2, whether we call it an occupation or a phase. That language seems pretty clear.
I guess sorry.
Go ahead.
I guess the development phase, that was considered when we drill all the remaining ones after the initial. We did have a phase that we left, and that was to do drilling commitment obligations in other areas that was occurring to the south around Broomfield. And so rather than having a long duration of a drilling rig and operations at one site, trying to break that up a bit. And so that's why we had moved that operation around during that time period. And we still had the obligation, we still knew that we needed to return. And that is why we continue to remove legacy wells in that area.
So it's either in the Form 2A or the WOGLA documents that even the phase 2 had a deadline date. So even if we're saying phase 2 didn't mean only 2 occupations, 1 and 2, there was an indication that everything would be done by a date certain. I'm wondering if you could address that and why that's in those documents, if that really isn't what your intent was.
Thank you for the question, Commissioner McGowan. And arguably, those timelines that you recite that were contained in those documents were the best laid plans at the time that those documents were submitted. When you look back over the last 10, well, let's just say 8 years, the world has been a very interesting place. And as economic conditions change, our ability to execute projects as we would like to execute them change as well. Given at the time, we were active in the city and county of Broomfield. Part of the reason that that timeline that you referred to in the WOGLA document was not met is we decided to focus on our operations in Broomfield to be able to bring those to a point where we were producing those wells and we were out of the Broomfield operational area in terms of pre-production operations. Beyond that, the only other thing I'll mention, and I know you all know this, is the oil and gas industry is very much like any other industry, right? You don't have to look any further than residential or commercial development, where those developers who are funding those projects may start off with a timeline, and at the end of the day, that timeline moves and shifts for any number of reasons, including those that I cited. I hope that answers your question, but more than happy to entertain it further if need be.
Yeah, it does. I think, to your point, many years have passed since the original occupation or phase one. And I think you see or are hearing from neighbors who are saying this is not the same place as it was when you started drilling, which already felt impactful to community. And so I'm wondering what your thoughts or opinions are to the points that they're making, which is this is not the same location there. It's significantly different. And so there has been a significant change to the surrounding area and potentially then some significant changes to what the operator you all are proposing for drilling and completions. And does that trigger a new OGDP?
Thank you for the question, Commissioner McGowan. And I certainly understand what the stakeholders, both represented here today, as well as those that filed written comment, are cognizant of or have drawn out in their remarks. To that end, when you look at the four corners of the location, to the question that Chair Robbins asked a little bit ago, there is no change, right? The pad is constructed, but for a small component we need to rebuild for our temporary freshwater storage facilities. The visual aesthetic nature of that location, the footprint within the landfill, none of that is changing. I will go back to how the location was originally permitted, right or wrong, to say that we are finalizing our intentions for this specific location and hope to do so with some improvements, as my peers have discussed today, relative to what was utilized in the prior phases of development.
And if I may, Commissioner McGowan, I think what is also important to understand, I think as Mr. Bennett alluded to, is that the nature of the change in the community around this location is with respect to the Broomfield Palisade community having come in, having been initially proposed to be platted in 2017 after, is my understanding, after the Coyote Trails pad was approved, but final platted in 2019, well after this operation was well underway. And I think they're, and as Broomfield said, that they, with full knowledge, I mean, they've been working with extraction for years now, with respect to not just the locations within Broomfield, but also as to this Coyote Trails pad, fully aware when they approved that plat and authorized that development, which, and as you could see from the photographs, is separated by an earthen feature that was in existence then and continues to this day.
Sorry, I've hijacked your questions, Mr. Chair. If you're okay with me asking one more along this vein,
Okay.
So could it be though that that Broomfield, for example, thought y'all were done with phase two, and then you start platting and building, and then neighbors know, okay, there's this location there. I'm cognizant of it. I'm still okay purchasing my house. It's a production facility. I think they're done drilling, or I've been told that they're done drilling because they've already done phase two. And that is a different circumstance when you move in versus, hey, there will be another occupation. And in this case, you all were considering two more occupations until you talk to our staff. And I think that is a different scenario and a different decision point for a homeowner to make.
Appreciate the question, Commissioner McGowan. And I understand, the intent behind your question. I do not have a good answer for you, only because, the fact pattern is, as I understand them, perhaps there should have been disclosures made by the city and county of Broomfield as part of that platting process, or the home developer, as evidenced by Mr. Schiller's comments this morning. The location is there. While we may be undertaking subsequent operations on that location, they were contemplated at the time it was approved by both the local government as well as ECMC.
Are you done, Commissioner McGowan, for now? Okay. I want to lodge a question to Mr. Prashala, and I'm going to give you some time to think about it, Mr. Prashala. It's a legal question. And then I'm going to recognize other commissioners with more specific questions. So in looking at our rules, 604B says no working pad surface shall be within 2,000 feet of an RBU unless one of the four exceptions is met: a waiver, a cap, the tanks or something are outside 2,000, or there's substantial equivalence. Working pad surface is defined to mean the portion of an oil and gas location that has improved surface upon which oil and gas operations take place. Oil and gas location is the definable area where the operator has disturbed or intends to disturb the land surface in order to locate an oil and gas facility. And finally, oil and gas facility is defined to mean equipment or improvements which is installed at an oil and gas location for the exploration, production, withdrawal, treatment, or processing of crude oil, condensate, E&P waste, or gas. I take all of those definitions, as well as Rule 604B, to mean to me, and I don't want to just say this during deliberations, that 604B applies not just to oil and gas development plans, but it applies to wells. And I want to give you an opportunity to try to convince me otherwise, because I believe that 604B requires this commission to do an analysis under 604B for these wells, and the application to date has not provided that. So didn't want to surprise you in deliberations. Want to give you a chance to think about that. And if you're ready to answer the question now, go for it. Otherwise, I'll look to my fellow commissioners for other discrete questions about the application.
I'm going to need a moment, Chair Robbins. Thank you.
Good. Then I'll give you the moment. Commissioner Messner.
Thank you, Mr. Chair. Mr. Piershala, while you're at that one, I had a similar question, Chair Robbins, a little different line, but I think Mr. Piershala tried to, at least from his perspective at the beginning of this presentation, present what he thought was the review criteria for this particular situation. My question to you, Mr. Piershala, is, understanding that you referenced, Rule 308C 1 and 2 as, ultimate decision points on this particular piece, and understanding that in both 308 C1 and 2, it clearly indicates that a Form 2 may only be approved or has to be denied if it doesn't protect and minimize adverse impacts to public health, safety, welfare, the environment, wildlife resources, which is referencing the statute and other elements in the rules. Are you indicating that what's being provided here today in your Form 4 submittals, in your Form 2 applications, and in your presentation today, this is your burden of proof in order to make that showing? This is the extent of your showing to make that determination, to grasp that burden for us to make that determination?
You're asking me whether the best management practices that exist, that have been proposed, including those of CDPHE, are reasonable and necessary conditions of approval in order to minimize. And
so my question is not a list of BMPs. My list is, do you feel like you've made a showing? Have you made a determination through your presentation and through the evidence that's provided? Have you provided a rationale on how you are making a showing that what you're providing is protective, right? So, you're providing a list of BMPs. That's great. That shifts the burden on the commission to determine whether or not that is adequately protective or not without you having to make a showing of that. And so I'm trying to understand, this gets back to, I think, Chair Robbins' determination in applying 604B, right? And the other potential plans that could be utilized by an operator in order to make a showing of whether or not what they're proposing is protective or not. What you seem to be providing is a list of BMPs. And so I'm trying to ask you, is there anything else that you intend to provide in making your showing?
so the question is, has multiple layers built into it. And I'm going to do my best to try to parse this through. I think what the standard that we are obligated to meet is contained within Rule 308. Rule 308 provides the sideboards on the analysis and review of a Form 2. I need to look at and give some more thought to Chair Robbins' question. So if I may have a moment on that. But 308 is our standard. What's been presented and what has already been considered by staff is that we have 48 best management practices that are already on this location. We have another host of best management practices that are being proposed that demonstrably reduce air impacts, traffic impacts, noise impacts associated with the drilling and completions phase. And that's been corroborated by CDPHE, that there will be a reduction in impacts associated with these operations based on the BMPs that have been proposed. If you're asking that we need to have data points that actually prove that each BMP is going to have some quantitative reduction in impacts, that's never been required. That's never been.
So what I'm
in any
asking
hearing
you
dispute.
is
May I finish?
there's plans that are required to be submitted as part of an OGDP that enables an operator to utilize those plans in developing their argument as to how the BMPs ultimately, are protective or not. And the benefit of utilizing those plans in a particular, in an OGDP setting is that you're able to use those narratives in order to develop that. As I'm reading 308 C1 and 2 and a potential review criteria that I'm utilizing, I think that those review criteria give an operator the ability to use whatever plans, whatever mechanisms, whatever tools that they need in order to be able to ultimately make a determination, to make a showing that they're being protective or not. And so I'm just asking if that was ever contemplated by you, because what I'm seeing is a list of BMPs, right? But I'm not seeing those other narratives, those other explanations, those other pieces that say, this is why I find it to be protective. This is why the transportation element of this is actually, protective. This is why the distance associated with this and the BMPs associated with the distance are protective. Whether you're applying the cumulative impacts plan, whether you're applying the traffic plan, whether you're applying the water plan. I'm just asking, like, whether or not you feel like you needed to do that or not, or whether you feel like it's adequate just to list some BMPs.
With that clarification, that's helpful, Commissioner Mesner. I think what we have is a Form 2 process that is delineated by Rule 308. That provides the information requirements that need to be submitted with a Form 2, including any best management practices that an operator feels are necessary, are reasonable and necessary as conditions of approval. There's not a requirement in Rule 308 to provide the equivalent plans that are required as part of an oil and gas development plan application. If that was the case, that would be built into the rule. And when we look at the rule scheme, we look at the operator training materials that have been provided, we look at Rule 308, and there is a distinction between what is to be submitted for an oil and gas development plan and what is to be submitted in support of a Form 2. If we were required to submit the plans that you're talking about that were with respect to an oil and gas development plan, then the rules should have said so, but it doesn't say that. So you're essentially asking us to.
I'm not determining that it's required or not. I'm just asking, do you think that those are helpful in making that showing? Because ultimately what we're going to have to make a determination here is whether or not what you're proposing protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources as per 308 C1. And so it also indicates, I think that there's a lot of different mechanisms that are available to an operator in order to aid the commission in being able to make that determination or not, right? There's not a prescriptive list. I was just asking whether or not you thought that those were things that would be helpful in helping an operator make that determination or not, or whether you thought that what was provided is adequate. That's the question, right? So a couple other questions. So there was a few different references in your presentation to reductions in VOCs and some other emissions, VOCs at 87%. Help me tie that to something. There didn't appear to be any submittals that would corroborate that reduction is accurate.
I would turn that question to Mr. Schlaubaugh, since he is the expert on air.
Yes, thank you for the question. Those numbers came from comparing the CDPHE Form 102s. So those, when we submit for permit applications, we do an emissions inventory of the full facility. So that looked back at, I believe it was 2017 during that permit application, and compared those numbers to the current numbers, and including
current numbers. Current numbers being what numbers? Like, what are the current numbers? We're not doing anything yet.
I'm sorry, are you asking the overall emissions?
I'm just trying to understand how to corroborate this claim that's made that you're going to have an 87% reduction in VOCs and other percentage reductions in other emissions. I mean, it's okay to say that, right? But I'm not seeing any evidence that would corroborate that. So I'm trying to understand that.
Make sure
there's no current operations happening, right? Besides production, right? I acknowledge there's production going, but I think what you were trying to say in this is that the BMPs that you're proposing for new drilling was going to have an 87% reduction of VOCs than previous pre-production activities. Is that fair to say that's what you were indicating?
I think I understand now. What we were looking at was the production emissions from the first phase, and then what the production emissions are calculated to be after these new wells are drilled. And
okay, so that has nothing to do with pre-production. That has nothing to do with the form 2s itself, but rather production. Is that correct?
The reductions are based on the improvements made to the facility. For example, the removing of the tanks and the pneumatic controllers, and other innovations since the initial phase.
And so another question along the same topic, because I went back and I looked at the original drilling operations that were happening on this particular location, and there was a number of sound studies that were done, and it appears that a lot of the BMPs that were being proposed on the original one from a noise mitigation standpoint are really similar to the ones that are being proposed right now in this particular application. The sound studies that were provided as part of that initial drilling operation showed dBA and dBc numbers that would exceed current noise regulatory thresholds. So what are you doing differently in this particular proposal that would ensure that there would be compliance with the current noise standards that were not in place previously? And I've got a number of different examples of where it exceeded what would currently be allowed in all through the fall of 2019.
Thank you for your question, Commissioner Mesner. We have undertaken more recent sound surveys to understand what impacts, if any, our go-forward operations during pre-production may have on the local communities. We collected some baseline data in April of 2023, and our sound consultant performed some modeling to understand how that noise may propagate into the community with the mitigations that we are proposing. That analysis shows that we will be compliant with present-day Rule 423. Further, we have some new sound data that was collected earlier this month, just to establish, again, what the current baseline is. We did see a slight increase in the January data that we collected relative to what was collected in April, which is a sign of activity going on outside the confines of our working pad surface. That's information that we can provide if that's something you're interested in.
Okay, I was just trying to better understand what you're proposing and how you intend to ensure that the nuisance factor is addressed.
I
I
appreciate.
think that's going to be the extent of my questions right now, Mr. Chair. I mean, I had a lot of the similar questions about at least from my perspective, the clear communication that was provided by the operator, both in the local permit process as well as within the Form 2A, that while it was indicated that, I mean, we're semantics here between phases and occupations, there wasn't an indication in both processes that this would be complete by 2019. So.
Okay, very good. Commissioner Cross?
Thank you, Mr. Chair. I do want to ask a couple follow-up questions on some of the topics that were addressed, including what Commissioner Messner was just mentioning. While I see the difference between a phase and an occupation, I'm curious if you have any kind of written information that signifies the number of occupations that were expected, not phases, but occupations that were expected at this site.
Commissioner Cross, thank you for the question. And if I understand it correctly, to the best of my knowledge, the company did not stipulate in writing, but for our most recent engagement with staff, that being during the APD approval process, that we would limit our occupations on this location.
Okay. And again, going back to some of the communications that happened before, one of the things that Mr. Frank testified about was the condition of approval to keep a sound wall up during the development phase. Do you recall that testimony, and can you explain whether that was intended to be just during occupations, or can you provide any kind of detail on that?
Yes, sir. Again, thank you for the question. I do recall Mr. Frank's testimony from earlier today. And I will say that the limiting factor, among other things, that was a cause for the removal of those sound walls was to comply with the Commission's 1000 series regulations as it relates to interim reclamation. Because there was a gap, if you will, in operations, the 1000 series regs, again, as it relates to interim reclamation, come into play. Since we had a period of inactivity to comply with ECMC's regulations, we removed the sound walls and put the pad into interim reclamation, again, so we could be compliant with the rules at hand.
I want to touch a little bit on, there was some discussion of removal of legacy wells and that playing into the timing of the occupations, both at this site and Broomfield sites as well. And I want to understand a little bit more on that. One of the things that was said, and I believe you indicated that you needed to get some of these wells in order to do the removal of those legacy wells. When you're referring to drilling that, I assume, first of all, let me know if I'm wrong with this, but I assume that you're talking about drilling wells in order to hold. And if that is the case, are you talking about drilling wells to hold leases at the Coyote Trails pad, or are you talking about drilling wells to hold leases at other locations, such as in?
I appreciate the question, Commissioner Cross. I'm going to ask Chandler Newhall to field the initial components of that, and I will be more than happy to fill in any gaps should there be any.
Yes, thank you, Commissioner Cross. It's a mixed, because certain legacy wells hold different acreage sizes, right? And so where you can remove certain wells and have a well that may hold a larger acreage position. Coyote Trails, as we developed it, we wanted to focus drilling towards the south because those legacy wells were in Broomfield and those horizontal wells were developing then that acreage. And so we wanted to meet the obligations of the vertical wells that were listed in the Broomfield operator agreement. The next then kind of phase was to look at wells that weren't in Broomfield, then that would be in Erie or in Weld County and other parts of the field that we could remove. And so that was part of that whole development strategy on, when do you drill these horizontal wells and the timing on the removal of those legacy wells. Hopefully, does that help answer the question that you had?
I think it does a little bit. And part of what I want to understand is, are there additional wells that need to be drilled from Coyote Trails that are dependent, that would allow you to do additional legacy wells, or are those legacy wells, it's just more of a plan?
Yeah, this is with this being the final occupation, and that's where we added the 2 Arapahoe wells that are in the town of Erie, because we were in conversations with the town of Erie on, there's an emphasis from them to remove legacy wells, so that way they can have more development in particular areas, in neighborhoods, in that sort of area. And so as we looked at Coyote Trails, where could we maximize removal? We knew we had the remaining young well that we had to remove, and we were attempting to bring in those 2 Arapahoe wells. We don't have further plans for horizontal development at Coyote, nor does it allow for other legacy well removals other than the 3 that we presented today.
Okay. And I will say, just kind of as a lead up to my next question, I think this highlights some of the benefits of having a CAP process and being able to kind of do this more large scale landscape planning with respect to when things are going to be drilled, when things are going to be plugged, etc. And aside from the single occupation that you're now proposing at this location, are there other potential occupations that you have in mind in this general area, and in this general area being around Broomfield, around Erie, closer to Boulder County, etc.?
There are other pending locations that are going through the approval process. And those sites do contemplate the removal of legacy wells in the areas that are within that DSU, and even contemplated legacy wells that are just outside that DSU. So yes, there are other OGDP applications that are in process that we've submitted that address legacy wells.
And all the proposals that you're talking about are specifically location based, not re-entering, not re-drilling additional Form 2s, but Form 2As. Sure.
Yeah, they're new locations.
Okay. And then I think I may have additional questions later, but I think one question that I want to touch on is, there was some discussion about the facility improvements that would be made if this is improved, that, as Commissioner Messner touched on, you indicated would have reductions in VOCs, reductions in NOx, etc. And I'm curious if those improvements to the facility are improvements that would happen regardless of.
So we're always looking for ways to improve and reduce emissions at our facilities. In 2022, we did remove the maintenance vessel that was out. We added the maintenance vessel and removed the maintenance tanks that were on location. We removed oil holding tanks as well as produced water holding tanks. And so, we're always looking for opportunities to enhance our, and reduce emissions from a location. I think adding more wells here, we're able to continue to always look at acceleration of enhancements. And so, to answer that question, yeah, we've already done some of these improvements, no matter that we haven't even started the drilling process. We've already made those improvements. And so as we see opportunities to make further improvements, that would be done as well.
Thank you. That's the only other questions I have for.
Other questions? Mr. Pashala, did you have a chance to think through my question?
I did. As I understand your question, Chair Robbins, is why does 604, you're asking me, why does 604B not apply in this circumstance? Is that a fair
Yeah,
summary?
essentially, I think I asked it in the reverse, is that, in my opinion, it should apply. And because it talks about working pad surface as well as the oil and gas location definition of oil and gas facility, knowing full well that we've not applied it to a Form 2 previously, but we've also not had the novel thing that we're dealing with today, which is a Form 2A that was approved 6.5 years ago under non-mission change rules. And I believe we provided the ability to apply the 604B and the ALA, locational piece to this novel circumstance. And I wanted to give you an opportunity to speak to that because it hasn't been addressed otherwise in the pleadings.
Sure. Well, I would start with the plain language of the rule. When we look at 604B, the title of the rule is citing requirements for proposed oil and gas locations near residential building units and high occupancy building units. Proposed is the operative word there. We're not proposing an oil and gas location. This is an existing approved oil and gas location. Just based on that, I would argue that 604B is inapplicable. I'd also just go further into that rule where we look at 604B4, where it says the commission finds, after a hearing pursuant to Rule 510, that the proposed oil and gas location and conditions of approval will provide substantially equivalent protections. Again, the word proposed, we don't have a proposed location here. But more importantly, when the commission did adopt Rule 604, it expressly contemplated and declined to apply it to existing oil and gas locations. And so I would turn your attention to the statement of basis and purpose on Rule 604. And it says, quote, the commission intends for Rule 604 to apply only prospectively and not retroactively, close quote. Continue, quote, consistent with Rule 602.1, Rule 604 does not apply to existing production facilities, including wells, flow lines, and oil and gas locations, period. The commission does not intend for existing equipment at existing oil and gas locations to change location as a result of adopting 604. Further states, in Rule 604B, the commission adopted siting requirements for working pad surfaces proposed to be located between 500 and 2,000 feet from one or more building units or high occupancy building units. So based on the plain language of the rule, as well as the statement of basis and purpose, I think it is absolutely clear that Rule 604B is not applicable to the Coyote Trails pad, and therefore is not applicable to the Coyote Trails APDs. Wells are not oil and gas locations. I believe that answers your question.
Thank you. Commissioner McGowan?
Thank you, Mr. Chair. But I thank you. I think along these similar lines, though, 308 does allow a pretty big door to walk through if the director feels like the Form 2 no longer is protective of public health, safety, welfare, and the environment. Do you agree?
I think that question is to me, Commissioner McGowan. Correct. I think, fundamentally, and when we had some back and forth on this several months ago about this process, and it's been Extraction's position from the beginning, and I would reiterate it here again today, that the commission rules and the commission determined, at the time of rulemaking, the mission change rulemaking, that this process for Form 2 was delegated to staff and the director, and they have the exclusive authority. And I would just reiterate that we disagree that the commission has the authority under Rule 503 to take this matter up on Form 2s on its own motion. And largely because, as the statement of basis and purpose states, is that it is the staff's expertise that is critical to making the determinations that are involved here with respect to the downhole considerations of Form 2s, but also as to the surface considerations as you're alluding to here now, Commissioner McGowan. And so I do agree with the premise that you're proposing that, yes, the rule does provide the director with the authority to take a look at surface impacts that may be associated with approval of a Form 2. And as part of that is to add conditions of approval that are reasonable and necessary for the protection of public health, safety, and welfare, and minimization of impacts. And that's what we've presented presented here today, is that these enhanced BMPs go further than what go very far to continue to minimize and mitigate impacts as well as provide protections. So we do. So if I'm answering your question, yes, I agree that Rule 308 does afford the director leeway to add conditions of approval that are reasonable and necessary.
So if I could follow up on that, and sorry, I'm trying to find my 308 now. We've been running around the 300 series a little bit. I actually don't read that the only way to deal with that is to add conditions of approval. I read that the director could deny.
I'm with you.
So that would be C2, right? The director may deny any Form 2 that does not meet all the requirements of the commission's rules or does not provide necessary and reasonable protections for or minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. The director will put forth a reason for denial. If the director denies a Form 2, the operator has the right for a hearing in front of the commission. So the director could deny as part of a review of a Form 2 and approval of a Form 2.
Yes, of course. Absolutely. And this
I thought I heard you say the director could only add conditions of approval. So I just want to make sure that you and I are on the same page.
No, we're on the same page. And I agree that the director would have the authority to deny, which actually goes back to my point as to why this is was supposed to be an administrative process that does give the operator an ability to appeal that decision. But extraction, under the process that's been adopted by the commission, extraction has been deprived of its due process right of that appeal within the administrative agency context. At this point, if the commission is to deny these permits, the only due process protection that extraction has at this point is now to appeal to district court. And so I go back to reiterating that this process is supposed to be, as per the rule, an administrative process. This was not to be open for a hearing in front of the commission. And certainly public comment that we had from this morning was not to be part of this process either. And to the extent that that public comment is influencing commissioner decision-making, I respectfully submit that is an error.
I appreciate your perspective and reading of the rules. I do think that it was made pretty clear during the rulemaking and then in the operator training that approval of Form 2s was not going to just be pro forma, and that there would be circumstances where it would require something other or perhaps denial. And I think we have an example of when the director said, can't approve this because something has changed significantly. And so I understand what you're saying, but I also think that we have some evidence before us that just approving the Form 2A is not necessarily what has to happen with the director.
Well, respectfully, the director hasn't said that she cannot approve these. We have had no findings from staff or the director on whether or not the best management practices that have been proposed as conditions of approval on the Form 2s get over that hump that you're alluding to. And the commission has taken upon itself to make that determination.
Yeah, and the commission has every right to do that, Mr. Pershala. You do agree with that?
Respectfully, we disagree, Chair Robbins. I think the laws and the rules are read clearly that the commission does not have that authority, that when you have a specific rule, such as 308, that does provide all the sideboards in the process and the standards of review for specific matter, that prevails over a more general provision in the rules. And we're just going to respectfully disagree on that.
Okay, well then let's get past that. You've made your point. Does anybody have any substantive questions for the panel? Further substantive questions? All right, seeing no further substantive questions, I will move this to deliberation phase, but I also want to take a break. It's 2:18. Let's return at 2:28 and take 10 minutes. All right, welcome back. It is still January 24th. It is 2:29, and we are on the record in docket 230900287. We have, I think, finished our questions to the applicant, and I believe we now are going to move into the deliberation phase. I see your presence there, Mr. Pashala. Did you have anything further, or are you just here to listen in?
Just appearing because we're back to hearing. Did not know if there were going to be further questions or process that would involve my client. Thank you.
I'm not seeing further questions. I'm seeing shaking of heads in the negative fashion. So I think we're just going to move into deliberations. So we will do that, and I will initiate deliberations on behalf of myself. First and foremost, I believe that the commission independently and accurately has the ability to raise consideration of the Form 2s from a director administrative determination to itself under Rule 503A, which states that the commission may, on its own motion, initiate proceedings upon any question related to oil and gas operations in the state of Colorado, et cetera. I disagree with the applicant that we don't have the ability to bring this to us. The applicant's reading that if there is a more specific process, then that would trump Rule 503A. I believe that interpretation would render Rule 503A useless or moot, because most of the other rules are more specific. And we're supposed to read everything together as if we're being lawyers. And so reading meaning into 503A, I believe, allows us to bring this to us. So that's the first point procedurally, is that this is before us. I will deliberate with my conclusion first. And then I'm going to give the rationale behind that. I believe that the Form 2s or the APDs do not meet the standards set by the Energy and Carbon Management Commission rules or the Act, and I will support a motion to deny the APDs with notice to the applicant that it may refile its APDs following submission of a Form 2A and supporting documentation and information as required by the rules. And here's the basis for that perspective. Generally, Rule 308C states the standard of review for every Form 2. Rule 308 applies here as the commission elevated consideration of the Form 2s to this hearing, which we're allowed to do. Rule 308C2 requires denial for any Form 2 that does not meet the requirements of ECMC rules or does not provide, quote, necessary and reasonable protections for or minimize adverse impacts to public health, safety, welfare of the environment, and wildlife resources, end quote. Rule 308C1B further provides that the commission will review an oil and gas location where the well is located to ensure that necessary and reasonable conditions of approval are applied to protect and minimize adverse impacts to public health, safety, welfare of the environment, and wildlife resources. And finally, Rule 308C3 provides that the commission may request any relevant, necessary, and reasonable information to determine whether to approve or deny a Form 2. The applicant carries the burden of proof as to whether the Form 2s today should be approved, conditionally approved, or denied. In this application, in 2017, the director approved the location where the wells subject to the pending Form 2s would be drilled. That was before Senate Bill 19181 or the resulting mission change rule changes. However, the amendments to the Act by SB 19181 and the current rules, in my opinion, apply to the Form 2s. As the location was not reviewed under the rules that apply to Form 2As, I do not, as one commissioner, do not believe we have the necessary information to meet Rule 308C1B requirement that is to review the location to determine what is reasonable and necessary conditions must be applied to the Form 2s. Therefore, a request to Rule 308C3 for information that would have been submitted for the location had it been permitted under the current rules is relevant, reasonable, and necessary. Without this information, I, as one commissioner, cannot adequately review the Form 2s and therefore believe denial is appropriate. But I would insert again the provision the applicant may submit the Form 2s after submitting all the other required information. I also believe that the change in circumstances in the area surrounding the location, including the addition of over 90 RBUs, and that number was kind of all over the place. It was 90 at one point, it was more than that at another point, within 2,000 feet of the location since it was permitted in 2017, coupled with the addition of 70 wells, constitutes a significant change to the location. The addition of 7 wells is a significant change to operation of an oil and gas location, and the commission must assess the resulting potential change in impacts, especially with the addition of so many new RBUs since the location was originally permitted. Under Rule 304A3, which I will read, 304A3 requires the operator submit and obtain approval of a Form 2A prior to any significant change to the design and operation of an oil and gas location, including but not limited to the addition of a well, et cetera, et cetera. I find significant change being the additional RBUs, as well as now the proposed 7 plus another 11, which they said they would submit, so 18 total new wells. Under 304A3, I think a new Form 2A is required for this location. Under 308A, the commission cannot approve the Form 2s without first approving a new Form 2A, and denial of the Form 2s is therefore required today, in my opinion. And finally, I asked the applicant's attorney about application of 604B. They do not believe that applies to a well that's associated with a pre-181 2A. I continue to disagree with that. Rule 604B, which went into effect in January 2021, prohibits any working pad surface from being located less than 2,000 feet from one or more RBUs unless at least one of the 4 exceptions applies. That's the informed consent, it's part of a cap, the tanks and batteries are otherwise outside of 2,000 feet, or there's a substantial equivalence finding. The siting requirement, in my opinion, in Rule 604B is not limited to only consideration of new applications and may apply at any time an applicant applies for a new or different operations on a location. And in this instance, I did note in my questioning earlier that we've not applied 604B to Form 2 well determinations, but we've also not been asked to deal with the novelty that is before us today, which is potentially 18 new wells within close proximity to many, many new people under a 2A that was approved 6.5 years ago, not under our mission change rules. While I don't believe the 3 exceptions B1 through 3 apply here, I, as one commissioner, cannot make the substantially equivalent determination required at 604B4 without all the other information required by that rule. Therefore, I cannot determine that an exception applies, and the wells may not be sited less than 2,000 feet from an RBU. And that's my justification for the place that I find myself with this application. I now will look to my fellow commissioners for their deliberative thoughts. Commissioner Messner?
Thank you, Mr. Chair. I'm really going to land in the same place as you. I'm going to just bolster the record just a little bit with some other findings that I've found. And so this will be a little bit all over the place because you hit on most of them that I would indicate. But I do want to just start with, as you indicated, I don't believe that the applicant has met its burden in showing that what's being proposed is protective of public health, safety, welfare, the environment, wildlife resources, as per 308 C1. And so therefore 308 C3 would apply, which is the denial of it. And there's a number of different reasons that you highlighted for that, and I generally agree with all of those reasons. But I also want to highlight the rationale that we developed as part of the mission change rulemaking in determining that the 2,000-foot setback was important, and that we utilize that as the presumptive setback for oil and gas activities from residential building units. And I'm not gonna read the whole section because it's multiple pages, but I will highlight that it starts on page 218 in the statement of basis and purpose, and it goes on for 2 or 3 pages, and it clearly lays out the rationale for why we made the determination that distance is an important consideration in protection of public health, safety, welfare, the environment, and wildlife resources, and the different mechanisms, studies, and testimony that we utilized in order to make that determination. And I think that ultimately becomes very applicable to this particular situation. And so I wanted to make sure that I highlighted that. I also want to highlight that in the statement of basis of purpose on page 13, there's a section on retroactivity, and it indicates that rules that involve activities that occur at existing facilities after January 15th, 2021, rather than specifying construction or equipment standards, are in fact intended to apply to existing facilities. Finally, when an existing oil and gas facility is significantly changed or modified, then the Commission's new rules apply, which may require an operator to retrofit existing equipment. The Commission emphasizes that many rules not listed in this paragraph are operational standards that apply to activities at existing facilities, and the absence of a rule from this paragraph is not intended to mean that the rule does not apply retroactively. Continuing down page 16, 17 in the statement of basis and purpose. Finally, compliance with the adopted and amended 200 to 600 mission change rules is necessary to ensure that the Commission and all permits it issues will not be in conflict with state statutes. The 200 to 600 mission change rulemaking was conducted to specifically implement 3 rulemakings required by Senate Bill 19-181, the mission change, the cumulative impacts, and the alternative location rulemakings, and other specific statutory changes made in Senate Bill 19-181. On page 52 of the statement of basis and purpose, and this goes back to the ability for the Commission to be able to make a determination on Form 2s, the references to the director in Rule 301A do not indicate that the director has complete authority over all permitting decisions, but rather recognize that there are a discrete subset of permits, including Form 2 permits to drill, that may be approved administratively by the director. It is not a shall, it is not a solely, it indicates a may in that particular situation. Also in page 53 of the statement is basis and purpose. It talks about substantive changes will require the submission of an amended permit application for the proposed operation. The Commission did not specifically authorize a formal public comment process for purely administrative changes to oil and gas development plans. However, the Commission will allow informal input from the public about proposed changes that may shape the director's determination of whether a change is significant and requires formal Commission approval, which will allow for greater formalized public input, which is what we've done here today. I think I'll stop there for right now. I do want to emphasize that I agree with you, Chair Robbins, about the ability for this operator to submit a Form 2A, a new OGDP, and provide all the necessary information for review. That's certainly an opportunity for this operator. I think that there's clearly been significant and substantial changes. And I think some of the things that were brought up that I think are appropriate is that the phasing changed. I struggle with the operator trying to indicate that they were not being clear that they had determined that they intended to do 2 phases to be completed in 2019, and not only the Form 2A that was provided to COGCC at the time, but also to the local government in their WOGLA process. And so completion dates have changed. I think the rules have changed, and certainly the surrounding land uses have changed, and we've got 90 new homes inside of 2,000 feet, including 28 affordable housing units. We've got some changes to access roads near the neighborhood, some additional commercial development that occurred in the particular area, as well as a number of other things. I will also indicate that the commission has already set precedents in requiring new OGDPs and new Form 2As on Form 2s, and that is the prospect decision, as well as a number of slides that were within the guidance documents provided by ECMC staff on how they would make determinations on whether or not it would be necessary to determine that a new OGDP or Form 2A would be required in applying the new rules. And finally, I think there was some argument that was provided by this applicant that CDPHE seemed to think that this was protective or not, but that is not the way that I read the CDPHE consultation in this particular situation. The fact that CDPHE had inaccurate information as part of their evaluation of this, as indicated that it was provided by the applicant. I understand that there could be miscommunications and that was probably unintentional, but I'm not sure that that evaluation was fully accurate enough to determine whether or not there was a significant reduction in emissions that were going to be associated with what was being proposed by the applicant. And I do think that the applicant had the opportunity in this situation to provide significantly more information in order to make a showing and rationalize whether or not what they were proposing was in fact protective or not, and they failed to do that. And so I think that's the extent of where I'm at right now. So thank you.
Thank you, Commissioner Messner. Further commissioners with deliberative thoughts? Commissioner Cross.
Thank you, Mr. Chair. I will be brief. I agree with you that we do have the authority to hear this on our own motion under 503A. I think that's clear, and we've made that clear in other determinations as well. I don't think I'm in a position to approve or deny it at this point in time. I think, as you indicated, I think there's a lot more information that we could still get to understand whether the proposed Form 2s would provide necessary and reasonable measures to protect and minimize effects to public health, welfare, safety, environment. So I think that, as Commissioner Messner mentioned, I think that there's a lot of information that's provided in the different plans that are required under a OGDP process. Not saying that those are required as part of the Form 2, but I think that given this unique situation, I think that additional information could be helpful in that area. I think it would be helpful to even, and again, as Commissioner Messner mentioned, there was some questions on noise, and I believe it was Mr. Bennett specifically indicated that additional information could be provided on noise and as to why they're meeting some of the noise requirements or rules now as well. So at this point in time, I'm not sure that I'm in a position to deny, but under 308C3, I would be in a position to request additional information from the operator to better understand how the proposed Form 2s would necessarily reasonably protect and minimize the impacts of the health, environment, and wildlife resources. And if we get to that point, I'm happy to put into more detail what information I think would be helpful.
Great. Thank you very much, Commissioner Cross, for those thoughts. Further thoughts from folks? Does anybody want to make a motion? Commissioner Messner?
So probably we'll need AAG Davenport to ensure that this is correct, but my understanding to be simple with this is I don't know as there's a two-step motion here, although Chair Robbins, I'd be interested to hear your thoughts. To me, it's a denial of the Form 2s that have been applied for. And I think an applicant always has the ability to resubmit a Form 2 or resubmit an OGDP in order to for us to consider even new operations on an existing location or in a different location, but I'm not sure that needs to be part of the motion or not. So AG Davenport, I don't know what your thoughts are there.
AG Davenport?
Thanks, Chair. Thanks, Commissioner Messner. I agree. I think that's your pleasure, Commissioner Messner, is to make a motion for denial. You do not need to specifically move or have commission approval of a motion that allows an operator to refile Form 2s or OGDPs. So if it's a denial is your motion, I think it can just be a one-step motion to deny.
Then, Mr. Chair, I make a motion to deny.
All right. I'll second the motion for discussion purposes. We have a motion and a second to deny. Do folks desire to further discuss this at this point in time? Commissioner McGowan?
Thank you, Mr. Chair. I just want to say thank you to everyone who provided information today and to my fellow commissioners. I think everything that could be said has been said, and I think that we're making an appropriate decision today. I will be supporting the motion to deny.
Further discussion, Commissioner Ackerman?
Thanks, and I also have been listening and agreeing with much of what has been said. I think this certainly illustrates the importance of good and clear communication, and particularly proactive communication. The best practice would be to communicate intent as early as it's known, especially in an area that's been of historic concern. I think in that way we can work through what will still be a complicated process, but one that might be a little more productive than an end result resulting from not significant communication. So I appreciate the considerable thoughts that have been set forth today, especially your explanation, Mr. Chair.
Further discussion on the motion? Not knowing what the votes actually look like, Hearings Manager Thomas, can we do a roll call for the vote?
Certainly. Commissioner Ackerman?
Yes.
Commissioner Cross?
No.
Commissioner McGowan?
Aye.
Commissioner Messner?
Aye.
Commissioner Robbins?
Aye.
Mr. Chair, the motion passes 4-1.
Thank you very much. All right, that concludes that matter before us today. I too want to commend everyone for participating. I think that this establishes that we are doing good work, doing hard work on behalf of the state of Colorado, and I believe this is the appropriate answer at this point for these applications, knowing as we've been indicated that there is an opportunity to refile with additional information. We've got 2 more OGDPs to consider today, commissioners. It is 2:53 almost. Let's return at 3 o'clock, and at that point, I would hope that the first OGDP is teed up for our listening pleasure. All right, welcome back, commissioners. This is the Colorado Energy and Carbon Management Commission, Wednesday, January 4th hearing. We now are taking up the next docketed matter on our agenda. Let me flip the page. This is 230700244, an oil and gas development plan. It is extraction, and it is called the Maverick 7N67W West OGDP. And I believe we will start consideration of this application with a presentation from someone at Weld County. Hi, Ms. Peters. Nice to see you again.
Good afternoon, Commissioners. Thank you for the opportunity to speak this afternoon in regards to the Weld County 1041 WOGLA process regarding the extraction oil and gas Maverick 7 and 67 West OGDP oil and gas development plan. Weld County Oil and Gas Energy Department held a pre-application meeting for the Maverick XOG 36 pad. And that pre-application meeting was on March 1st of 2023, at which several alternative sites were discussed. Attendees included Weld County staff, extraction and their consultants, ECMC staff, CPW, CDPHE, BLM, the town of Severance, and the town of Windsor. And I apologize, those are who were invited. The CDPHE, BLM, town of Severance, and the town of Windsor were not in attendance, but we do send copies of the meeting minutes to all invitees and attendees. At time of the 1041 WOGLA notice, a case number was assigned, which is 1041 WOGLA 23-0015. The initial 1041 WOGLA application was received on June 8th of 2023. And after further discussion with the applicant to clarify and enhance certain items, the final application version was submitted on June 15th of 2023. The application included an analysis of 8 alternative sites, which were reviewed and discussed in detail with OJED staff and the hearing officer. There are 2 Weld County defined building units within the 1041 WOGLA zone. The closest being in approximately 1,656 feet to the southeast. Weld County notice of hearing included 26 parcels, but after removing duplicates, Weld County sent 11 individual property owner notices. Weld County did receive phone calls from 2 landowners who were within the 1041 WOGLA zone. Lawrence Kubo asked staff where the location was being proposed, and Weld County shared a map to the landowner, showing that the location is not on his parcel. And the other question was in regards to traffic, which would not be going past his access road or his house. The second interaction was with David Lind, and he had questions in regards to his minerals. And after staff had shared the development area drawing, the wells do not access his minerals. Other than that, Weld County did not receive any requests to participate in the hearing. The referral requests were sent out to multiple agencies on June 21st of 2023. Responses were received from internal departments from Environmental Health, Weld County Department of Planning Services, and then state agencies for CPW, ECMC, CDPHE, Windsor Severance Fire Rescue, and Weld County Office of Emergency Management. Responses were not received from the town of Windsor, town of Severance, Eaton RE2 School District, Windsor RE4 School District, and the BLM. The 1041 WOGLA hearing was held on August 10th of 2023. The hearing officer considered testimony at the hearing, and at the conclusion of the hearing officer found the application complete and compliant with Weld County Code requirements and approved the permit. The final order was recorded with the Weld County Clerk and Recorder on August 23rd of 2023. And it was subsequently published in the Greeley Tribune on August 25th, of 2023, which creates vested property rights for this permit. From a land use perspective, this is a good location. It is close to other oil and gas development. 2A comments were submitted to the ECMC on December 4th of 2023 and are included in the director's recommendation. With that, Weld County agrees with the director's recommendation and supports approval of this permit. And as always, I'll remain on the Zoom call for the duration of this docket if any further questions are to be had.
Thank you, and thank you very much. We, again, always appreciate the perspective of the relevant local government, that being Weld County in this instance, so we appreciate your being with us through a lengthy day. All right, Ms. Fulcher, do you want to have your witnesses visualize themselves, and then we'll get them sworn in by AAG Mercer?
Yes. Yes, thank you, Chair. Good afternoon. Scanning to make sure everyone is turning video on. And I do believe we have everyone present now with video on. So if Ms. Mercer wants to proceed in the swearing in, I think we're ready.
Thank you very much, Ms. Fulcher and Mr. Chair. Good afternoon to members of the panel. I will just go one by one and ask you each to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Annable.
My name is Jeff Annable, and I swear to tell the truth.
Thank you. Mr. Roush.
Good afternoon. My name is Caleb Roush, and I swear to tell the truth.
Thank you. Mr. Miller.
My name is Stephen Miller, and I swear to tell the truth.
Thank you. Mr. Marshall.
My name is Zach Marshall, and I swear to tell the truth.
Thank you. And Mr. Flanagan.
My name is Sean Flanagan, and I swear to tell the truth.
Thank you. I believe that's everyone unless I missed someone, Ms. Fulcher.
You got everyone, Ms. Mercer. Thanks so much.
Thank you.
Chair, with your permission, I think we're ready to proceed.
Oh, yeah. Permission granted.
Thank you very much. We do have a slide deck to present to you today. I think we'll keep it off for now as I have some opening remarks, and then we'll start with our screen share. Just want to tell everyone here, good afternoon. Good afternoon to ECMC staff and members of the public. I know it has been a long day, so hopefully we can keep this brief. I'm Jill Fulcher, shareholder of Beatty and Wozniak, here today on behalf of Extraction Oil and Gas in docket number 2307-00244. This is an application to establish the Maverick 7N 67W West Oil and Gas Development Plan. Mr. Annable will be walking through the majority of our slides today, but before handing it off to Jeff, I will provide an overview of this OGDP. The Maverick OGDP totals approximately 744 acres. That includes a 720-acre existing drilling and spacing unit, which is comprised of portions of sections 2, 3, and 4 of Township 6 North, Range 67 West. And those are the target mineral development area for this OGDP. The OGDP contains one proposed oil and gas location located within a portion of the northwest quarter of the southeast quarter of Section 36, and that is in Township 7 North, Range 67 West, and that is the Maverick XOG 36 pad. The Maverick 36 pad is proposed for 4 wells only, without any production equipment or facilities proposed at that location. All fluids produced from the Maverick 36 pads will be transported via pipeline to the existing Iceman 36 in location, where oil and gas will be separated and transported via pipeline to a gathering system, and produced water will be trucked to a disposal facility. The Iceman 36 in pad is not being expanded, so a Form 2A is not required. However, Extraction is making some improvements to that pad, including installation of previously permitted separators and also an installation or replacing a tank with a maintenance vessel. As you will hear, the Iceman 36 in facility is already powered electrically, and Extraction will continue to utilize electric power for production facilities at this location. As mentioned by Ms. Teeters, and we thank you very much to her for being here, the Maverick 36 pad is within Weld County, and Weld County has approved a 1041 permit for this location. The town of Severance is approximate local government to this pad, or this, this proposed location, excuse me, and Extraction has provided Severance with all notice requirements, has met with Severance, and Severance has not communicated any concerns with this proposed development. Extraction's presentation today, along with the evidence in the record, will demonstrate that the Maverick Oil and Gas Development Plan allows for mineral development in a manner that avoids, minimizes, and mitigates impacts to the public, environment, and wildlife. A few highlights to note for you. The utilization of the existing Iceman oil and gas location for all production, processing, and separation will minimize the size of the proposed Maverick 36 pad, as well as minimize construction disturbance and time on site. The proposed Maverick 36 pad avoids all high priority habitat, high occupancy building units, schools, disproportionately impacted communities, and childcare facilities, as well as floodplains and public water systems. The Maverick XOG 36 pad is within approximately 1,800 feet of one RBU and is upgradient of a wetland. So an alternative location analysis was conducted to determine if an alternate location was preferred. Extraction identified 6 alternate locations that could develop the target minerals and concluded that each alternate location would result in greater impacts to the public or to surface use and would not be more protective than the proposed Maverick 36 pad. That was the same conclusion that was reached by staff as part of the director's recommendation identified on page 5. Extraction has obtained informed consent from that single residential building unit owner coming within 2,000 feet of the proposed pad. And Extraction also notified all owners within 2,000 feet of the existing Iceman location, even though that location does not require a new Form 2A. And there were no objections or comments received even from those owners that are within the Iceman buffer area. And finally, Extraction will utilize or will drill all 4 wells utilizing a Tier 4 equivalent drilling engine. Right now, that is planned with natural gas power and battery assist, as well as committing to using Group 3 drilling fluids. Notice was provided to all interested parties. Again, no comments or petitions were received. And finally, the director has reviewed all elements of this OGDP and has recommended its approval under Rule 306B1, finding that all of your rules have been met and the requirements of ECMC rules have been met, and in the director's judgment that this OGDP is protective of public health, safety, welfare, and the environment. Before I hand it over to Mr. Annable, I did want to address one of 2 of the questions that we did receive in advance from commissioners, and that pertains to language on page 3 of the director's recommendation. There's some language in that director's recommendation stating as follows: Extraction acknowledges that to drill all 8 wells authorized by order number 407-2211, it would be required to seek commission approval of an amendment to the Maverick OGDP. So the commissioner question was what was meant by this language and whether Extraction planned for additional occupations at this OGDP or a single occupation, or if there was an intent to come back and drill more wells. So I'll provide you the short answer to that question. The answer is no. The plan is for a single occupation here and for this oil and gas development plan area to be fully developed with these 4 wells. So the short answer is no, single occupation. To give a little bit more color on this language, Order 407-2211 is the existing order that established the drilling and spacing unit for the mineral development area back in 2017. And at that time, the order approved up to 8 wells for horizontal well development. Didn't require all 8 wells to be drilled, but approved up to 8. More than 6 years later, Extraction has the benefit now of analyzing some additional data, including additional drainage data. And based on that, has determined that it's 4 wells here that is the most efficient development for this acreage. This is very similar to the testimony and to what was presented to you back in November of 2023 for the Jesser Oil and Gas Development Plan, where based on additional data, we learned that we can do more with less, and we can develop just equivalent resources with fewer number of wells. So there is an existing drilling and spacing unit that contemplates 8 wells, but that is not the plan now here in 2024 as it stands today, based on what we know to be true of drainage. And that information was supplemented to the engineer as part of this docket. So the staff gave us, rather than amending the prior order, staff recommended this language. So this language was made at the request of staff rather than to amend the DSU. Instead, we were asked to acknowledge that if ever those additional 4 wells in the DSU were to be drilled, we'd have to come back before this body, and Extraction agrees with that. So that was the purpose of the language, and I hope that that clears everything up. But again, the plan here is just a single occupation to drill these 4 wells. So with that, I will ask Mr. McKee to go ahead and start the share screen, and Mr. Annabelle will walk you through the slides.
Thank you, Jill. Good afternoon, commissioners. Thank you for taking the time to hear our Maverick OGDP. My name is Jeff Annable, Manager Well and Location Permitting for Civitas Resources, Inc., parent company of Extraction Oil and Gas. Next slide. Before you is an overview of topics that we intend to cover during our presentation. First, we'll give a brief overview of the OGDP. Then we'll cover our alternative location analysis, community outreach, best management practices, and last, we will summarize our presentation and request approval. Next slide. I will be the sole presenter today, but here's a list of subject matter experts that are available for questions after the presentation. Next slide. Now I will give a brief overview of Extraction Oil and Gas. Extraction is a wholly owned subsidiary of Civitas Resources. Civitas and its subsidiaries had multiple OGDPs reviewed and approved by this commission. Extraction maintains all operating requirements and will be the operator of the Maverick XOG 36 pad, the only location proposed in this OGDP. Next slide. Now I'd like to cover the procedural background of this OGDP and provide some general information. Next slide. Before you is a list of procedural milestones. The Maverick OGDP was filed on July 28th of 2023 and was deemed complete on November 16th. During technical review, operator consulted with CDPHE and the comment petition period closed with no comments or petitions filed. On January 16th of 2024, the director provided the recommendation of approval. Next slide. Now I'd like to provide some general facts regarding our proposed OGDP. The Maverick 7N67W West OGDP encompasses 744 acres, which includes the pad disturbance and a 720-acre existing drilling and spacing unit. This acreage will be developed by constructing a new location, the Maverick XOG-36 pad, to contain 4 wells that will flow to the existing Iceman 36-N pad facilities that will not be changed other than upgrades and the previously approved separators that will be added. There is 1 RBU within 2,000 feet of the proposed working pad surface, which is 1,808 feet from the nearest edge of working pad surface. Extraction consulted with this RBU owner within 2,000 feet and was able to secure an informed consent. The location is not within or immediately adjacent to any disproportionately or cumulatively impacted communities, high priority habitats, and did not receive any public comments from the public during the local and state permitting process. There is a non-mapped wetland located in cultivated cropland immediately downgradient of the proposed location. Operator has worked with CPW and obtained a waiver for this wetland. Next slide. Now I'd like to briefly cover the relevant local government process. Next slide. First, I'd like to thank Ms. Teeters and Director Maxey and staff at Weld County for their thorough and efficient review. We kicked off the Weld County 1041 WOGLA process with our pre-application consultation, during which ECMC staff and proximate local governments were in attendance. During this meeting, there was no major concerns with the proposed development. Next, we had the hearing for the location on August 10th of 2023, where no applications of interventions were filed and the hearing officer granted approval. Next slide. Next, I would like to cover the anticipated phases of development. Next slide. If approved, Extraction anticipates beginning construction in August of 2024, followed by drilling and completions through November, and flowback and production in December. After flowback is completed, Extraction will begin interim reclamation operations no later than January of 2025. Next slide. Now I'd like to cover our alternative location analysis that was performed as a part of this OGDP. Next slide. We conducted an alternative location analysis to identify potential sites for developing the proposed acreage. We first evaluated the expansion of existing location, which consists of alternative location number 5 and alternative location number 6. These locations had a greater number of RBU owners within 2,000 feet of the proposed working pad surface. We then explored building new location, which consists of alternative locations 1, 2, 3, and 4. But they were also unsuitable due to various reasons, such as surface owner refusals, increased agricultural impacts, or increased cumulative impacts due to the need for standalone facilities and midstream build-out. Therefore, we concluded that none of the new locations provided the same benefits of the proposed location. Next slide. Now that we have went over the alternative locations, I would like to provide our rationale of why we decided to utilize the Maverick XOG-36 pad. The proposed working pad surface is located in a way that reduces the effects of pre-production activities by keeping a large distance and low number of RBU owners within 2,000 feet of the site. It also lowers the overall impacts by using an existing utility-powered facility and midstream infrastructure on the nearby Iceman 36-N pad. Next slide. Now I'd like to cover community outreach that was performed by Extraction. Next slide. We consulted and obtained an informed consent from the only RBU owner within 2,000 feet of the planned working pad surface. Additionally, we consulted with the RBU owner next to the planned access road, who had no objections to development. But we voluntarily agreed to put hay bales next to the planned access road to reduce impacts during pre-production operations. And finally, we notified all RBU owners within 2,000 feet of the Iceman 36-N pad of the hearing, none of which provided comment or requested consultation. Next slide. Now I'd like to cover our proposed cumulative impact mitigation and best management practices. Next slide. First, I would like to go over our cumulative impact mitigation investigations that we did as a part of this OGDP. Extraction looked into powering the rig using utility power, but it was determined that the grid, without substantial upgrades, does not have the capacity to power the rig. Although we were not able to power the rig, I think it is worth mentioning that the Iceman 36-N pad production facility is currently and will continue to be powered by utility power. Next, I would like to discuss our findings on the feasibility of a produced water pipeline. We found that the closest disposal well is about 11 miles away from the planned site. Extraction calculated that building a pipeline of this length would have more negative effects on traffic and land use than transporting the produced water from 4 wells by truck. Next slide. Now I'd like to go over the cumulative impact mitigation that is generated from our location siting. The proposed location does not have any high occupancy building units, schools, outdoor activity areas, or high priority habitats within 1 mile of the proposed location. Additionally, this siting allows for the utilization of 790 feet of an existing access that has a 50-foot hard apron currently installed, which helps mitigate potential dust impacts. The location also allows for the use of the existing facilities and midstream infrastructure at the Iceman 36-N pad. Finally, I would like to also mention that this pad was originally permitted at a location that was 501 feet from the nearest RBU, which is alternative location number 3. And in an effort to minimize potential impacts, that development plan was abandoned in favor of the Maverick OGDP that is presented to you today. Next slide. Next, I would like to cover some cumulative impact mitigation reductions proposed at the Maverick XOG-36 pad regarding construction. Since the location has wells and a gas lift meter shed, the size of the location during production operations has been greatly reduced. Moreover, an avian survey will be completed prior to the commencement of construction to confirm no conflicts. We will utilize fresh water as necessary to reduce dust impacts. And finally, the topsoil stockpiles will be constructed and stabilized to provide short and long-term stabilization. Next slide. During drilling operations, Extraction is proud to be able to commit to utilizing a Tier 4 equivalent rig that is natural gas with a battery backup. If available, a Tier 4 powered drilling rig will be utilized. In addition to the Tier 4 equivalent drilling rig, or better, we will use Group 3 drilling mud, closed loop drilling system, and a pipe cleaning procedure when removing the drill string from the hole for odor mitigation, 32-foot sound walls around the entire pad for noise mitigation, and finally a polyethylene liner on location as an additional spill prevention measure. Next slide. Before you is a list of cumulative impact mitigation measures and site-specific equipment related to completions. I'll go over some of the major highlights. A temporary lay-flat water line will be used to source water, and a Tier 4 equivalent or better completion fleet will be utilized. And finally, flowback will be routed through permanent production equipment, allowing gas to be controlled and sent down the pipeline or combusted with a 98% efficiency. Next slide. To conclude, I would like to cover the production phase. The Iceman 36-N pad is currently electrified and will be upgraded with instrument air and a maintenance vessel. The oil and gas will be piped off location. The location will be equipped to shut in remotely and will be painted in a way that blends with the surrounding landscape. We also are proud to plug and abandon the Bauer 15-3 and 10-3 wells and associated production facilities as a part of this project. This will result in 0.66 acres reclaimed, the removal of 2 oil tanks and 1 water tank. This beneficial impact will remove wells and facilities that are currently located within 2,000 feet of 20 plus RBUs and an elementary school. Now I'd like to take a moment to answer an additional commissioner question regarding emissions accounting. By using instrument air and a maintenance vessel, we can reduce the amount of gas that is vented to the atmosphere, which is important. The maintenance vessel allows us to control at least 95% of all unplanned maintenance emissions at the pad. Unfortunately, these emissions savings are hard to quantify, as we can't predict the maintenance that will be needed to take place over the course of the life of the wells. Additionally, the wells that are going to be plugged and abandoned have not produced in significant enough quantities over the past couple of years, and therefore would not result in a significant emissions reduction. But while this doesn't result in significant emission reductions, I think it is important to remember that this development utilizes existing facility, which reduces cumulative impacts associated with building a new facility. And I would like to conclude that all emission reductions have been accounted for in our emission estimates on the associated Form 2B. Last slide, or next slide. Civitas would like to express its gratitude to Director Murphy and the ECMC staff for their diligent and thorough evaluation and preparation of the Director's recommendation of approval. I would now like to discuss some brief highlights. Next slide. Operator did consult with CDPHE as part of this project and obtained a Rule 1202A3 waiver from CPW for the proximity to downgradient wetlands. 6 alternative locations were analyzed and were determined to have greater impacts than the proposed location. Operator was able to obtain an informed consent and voluntarily agreed to place hay bales along the access road to mitigate potential impacts to the homeowner along the access road. And finally, the risk of water resource impacts will be minimized by the proposed BMPs, ultimately resulting in no significant potential for adverse impacts to environmental or wildlife resources. Next slide. Now I'd like to hand the presentation back over to Jill to close out. Thank you, commissioners, for your time.
Thank you, Jeff. Brian, you want to go ahead and take it to the last slide here? This is the last slide from extraction here today. In the interest of time, I'll just skip through the notes I had here. This is just a high level summary of the ways in which this OGDP avoids, minimizes, and mitigates impacts to public health, safety, welfare, and the environment. We once again want to express our gratitude to the staff, to Weld County, to the town of Severance, and to CDPHE for the consultations and review and feedback throughout this process. And again, want to thank this commission for your time here today and also leading up to this hearing. And we know that you take quite a bit of time in looking through all of these materials and reviewing the portfolio. So we thank you for that and for those advanced questions. This concludes our presentation. We're available for questions, and we would respectfully request that following deliberations, you approve the Maverick OGDP. So with that, if our panel wants to visualize themselves for questions, and then if we want to go ahead, I think it's stop screen share to make ourselves bigger, and we're here for questions. So thank you again.
Thank you very much, Ms. Fulcher, and thank you to the panel for the presentation. Commissioners, the panel is open for questions. Commissioners, the panel is open for questions. Commissioner McGowan.
Thank you, Mr. Chair. My questions were submitted and have been answered. I can start deliberation if folks want.
Go for it.
I think there were a lot of things to appreciate about this application. Appreciate looking at using an existing facility to for the actual production facilities, which minimizes the impact of the wells on the site. Iceman is already electrified, and they're going to make some upgrades to make some further improvements to that site. My questions about emissions reductions and the benefits of plugging the wells have been answered. Looks like they're agreeing to a one-time occupation only, and I would recommend approving this OGDP.
Thank you for starting out with deliberations and noting the positive aspects of the proposal that is before us. Does anyone have further deliberative thoughts or want to second the motion?
Second.
Commissioner Cross has seconded the motion. We have a motion and a second to approve the OGDP. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. The OGDP is approved. Thank you very much, Ms. Fulcher, and to the panel, as well as to our staff for bringing an approvable OGDP through the process and to us for our consideration today.
Thank you very much.
All right, we have one more matter before us. It is docket 2308-00259, an oil and gas development plan. This is over on the west slope. It's Laramie Energy. As is normally the case, let's see if we can remove the extraction folks, bring up the Laramie folks, take 5 minutes and return at 3:38. All right, welcome back, folks. Colorado Energy and Carbon Management Commission. It is January 24th. It is about 3:39, and we're taking up docket 2308-00259, an oil and gas development plan proposal by Laramie Energy. And I believe we're starting with a short presentation by Rebecca Treats from our staff. You're muted, Ms. Treats.
Apologize, I'm trying to get my share screen up. Just a second.
No problem.
Okay. So there were 4 conditions of approval put on in the Form 2A and the director's recommendation regarding the Laramie Energy Courier BCU. Since the director's recommendation was published, there was some discussion between the operator, the environmental group, and reclamation to make a few modifications to the conditions of approval. So based on that, there is the original COA for number 3, that interim reclamation shall commence no later than 6 months post-completion operations. If interim reclamation does not occur within the timeframe outlined in Rule 1003B, a variance request will be required if interim reclamation does not commence 6 months post-completions operations. This was modified to say, interim reclamation shall commence no later than 6 months post-completion operations or subsequent operations, unless the director extends the time period because of conditions outside the control of the operator, pursuant to Rule 1003B. If interim reclamation does not occur within the timeframe outlined in Rule 1003B and the director has not granted an extension due to conditions outside the control of the operator, a variance request will be required. That is the first one. The second one is for COA number 4. This is the initial was if the initial characterization samples for drilling cuttings exhibit exceeds the soil sustainability for reclamation criteria, and the operator shall submit a Rule 915B request and a reclamation plan with the required site-specific information as detailed in Rule 915B soil sustainability for reclamation. The operator guidance document is attached in the initial Form 27 as required by Rule 905E2A. Exceeds of inorganics left on location are not permissible. This has been revised for clarification of the inorganics that shall exceedances of inorganics left on location are not permissible without ECMC approval of a separate Rule 915B reclamation plan. Approval of the waste management plan attached to this Form 2A does not constitute approval of the Rule 915B that was part of the waste management plan. Reclamation plan or approval of exceedances and inorganics to be left on the location at that time. So it was a clarification for the inorganics and the timing of interim reclamation. I am happy to take any questions.
Great. Thank you very much. Does any commissioner have questions? If you want to drop the screen share, I'll be able to see folks if they're raising hands. All right, we will take that as submitted. Thank you very much. We appreciate you being with us. We appreciate all the hard work on the application. Ms. Weslinky, good afternoon. Do you want to visualize your witnesses so we can get them sworn in?
Yes, thank you, Chair. If all the Laramie team could please camera on and be ready to be sworn in.
Thank you. Good afternoon, members of the panel. I will go one at a time in the order that you appear on my screen and ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Middleton.
Hello, my name is Katie Middleton. I swear to tell the truth.
Thank you. Mr. Caston.
Hello, my name is Matt Caston, and I swear to tell the truth.
Thank you, and apologies for mispronouncing your name.
Okay.
Mr. Bankert.
Hello, my name is Wayne Baker, and I promise to tell the truth.
Thank you. Mr. Edge.
My name is Austin Edge, and I promise to tell the truth.
Thank you. Mr. Knudsen.
My name is Dwayne Knudsen, and I swear to tell the truth.
Thank you, and apologies to you as well.
No problem.
Mr. Peters.
My name is Tyler Peters, and I swear to tell the truth.
Thank you. Mr. Cooley.
My name is Duke Cooley, and I swear to tell the truth.
Thank you. Mr. Lowry.
My name is Jason Lowry, and I swear to tell the truth.
Thank you. Ms. Wilsey. You're on mute.
My name is Amy Wilsey, and I swear to tell the truth.
Thank you. Mr. Brodsky.
My name is Edward Brodsky, and I swear to tell the truth.
Thank you. And finally, Mr. Duncan.
My name is Aaron Duncan, and I swear to tell the truth.
Thank you very much.
All right, we've got the panel sworn in. The virtual video is yours.
Thank you, Chair. Thank you, Commissioners. We do have a PowerPoint. We'll just bring that up and then I will get started. Great. Well, good afternoon again, Commissioners. My name is Kelsey Wasalinki with Jost Energy Law. And with Jamie Jost, we represent Laramie Energy, LLC in the 2023 Courier BCU 0993-16-07 OGDP before you today in docket 2308-00259. We would like to thank Mesa County for its support of the Courier BCU OGDP and also ECMC staff and the director for their efforts on this OGDP, and also to Ms. Treats for her clarification of the COA language. Next slide. I'll take just a few minutes to summarize the Courier BCU OGDP and requested relief before I turn it over to Laramie. This OGDP requests that the Commission establish an approximate 480-acre OGDP for the development of 23 new directional wells in the Williams Fork and Isles formations in Mesa County. The OGDP also requests that the Commission approve one Form 2A for the Courier BCU 0993-16-07 pad for the development of 23 new directional wells. The majority of the mineral development area is located within the 4,800-acre Buzzard Creek Federal Exploratory Unit. Laramie will drill 21 wells within the Buzzard Creek unit and 2 outside of the unit within leasehold owned by Laramie. 3 of the 23 proposed wells are federal wells, and Laramie filed the federal APDs in July of 2023. As of the date of this hearing, the federal APDs are in the final stages of review by the BLM. Laramie will develop the 23 proposed directional wells pursuant to Piceance Basin-wide Order 1-229, which established well density and subsurface setbacks. The Courier BCU pad is located within Mesa County. Laramie has an approved Mesa County oil and gas site location, approving the siting and related surface disturbance for this location. The proposed Courier BCU location does not trigger any Rule 304 ALA criteria. And as part of the OGDP, Laramie has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, which Laramie will describe today. These include using a natural gas or dual fuel rig, fresh water-based drilling mud, and existing and new water gathering lines utilizing recycled produced water. And finally, Laramie has complied with all notice requirements for the OGDP. No formal petitions were filed and no public comments were received on the Form 2A. I'll turn it over to Katie Middleton, the Senior Permitting and Environmental Planner for Laramie, to continue the presentation.
Hello, thank you. Next slide. Thank you, Ms. Wasylinski. Good afternoon to Robbins and Commissioners. My name is Katie Middleton, and I am the Senior Permitting and Environmental Planner for Laramie Energy. Laramie would like to thank the Commission for the opportunity to present the 2023 Courier BCU 0993-1607 OGDP today. Laramie would also like to thank Mesa County, the BLM, CPW, and ECMC staff for their guidance and time with this project. Laramie is an exploration and development company that solely operates in Western Colorado. Our core operating areas are in Cascade Creek and Plateau Valley, both located within the Piceance Basin. Next slide. During this presentation, I'll refer to the location as the Courier BCU. The proposed Courier BCU well pad is a new oil and gas location located in the Plateau Valley within Mesa County. Laramie appreciates the clarifications made to the COAs contained within the Director's recommendation by Ms. Treats today, and Laramie agrees to all of the COAs as modified by Ms. Treats' remarks. I will address the Commissioner question on soil sampling and drill cuttings COA later in this presentation. From the Courier BCU well pad, Laramie is proposing to drill 23 directional natural gas wells, composed of 20 fee wells and 3 federal wells. Of the 23 wells, 21 are within the Buzzard Creek field. The site will be located on private surface lands in which Laramie has secured a surface use agreement to access and develop the location. Next slide. Before you is an overview of the Courier BCU application timeline. Laramie began evaluating the development in Section 16 in the second quarter of 2022. During the preparation of the OGDP, Laramie conducted 3 pre-application meetings with regulatory agencies, including 2 virtual meetings and 1 on-site meeting. Other significant milestones worth noting are the submittal of the 3 federal APDs to the BLM and the approval of the Mesa County oil and gas location permit. No public comments were received and no petitions were filed. Next slide. The Courier BCU is located in a remote mountainous area of Mesa County. The site is located 9.5 miles east of the town of Colburn. Highway 330, the nearest public road, is located 2,690 feet south of the site. The site will be accessed from a new access road and existing private lease roads. There are no residential building units within 2,000 feet. In addition, no high occupancy building units, school properties or facilities, child care centers, or designated outdoor activity areas are located within 1 mile of the proposed location. Next slide. The Courier BCU is located near existing infrastructure owned and operated by Laramie. The existing access lease road and pipeline corridor will minimize surface disturbance associated with this project. Nearby facilities include a water treatment facility, saltwater disposal wells, a gas compression facility. By utilizing temporary surface water lines and tying into existing water gathering lines and gas pipelines, these nearby facilities will support proposed operations and reduce truck traffic associated with the development of the Courier BCU. Approximately 75% of water which will be utilized during pre-production activities will be recycled water. Next slide. The Courier BCU was designed to minimize surface disturbance while providing safe and efficient mobility for equipment and personnel. The proposed area of disturbance will be 9 acres and 1 acre for the access road. The proposed buried gas pipeline and water line will be installed with an existing pipeline corridor and will result in 0.9 acres of disturbance. During an interim reclamation, 6.9 acres will be reclaimed, leaving 2.1 acres for the production pad surface. The Courier BCU OGDP will result in 3.1 acres of long-term disturbance. The design of the well pad incorporates protective stormwater and drainage control measures, in addition to management and remediation of drill cuttings. Stormwater BMPs were designed and reviewed by a certified stormwater contractor and professional engineer with extensive stormwater experience on the western slope. Laramie received a commissioner question regarding the COA for soil sampling and drill cuttings, and whether Laramie believes we can meet these conditions, or if Laramie wishes to discuss a variance for the longer runway as part of the OGDP. The drill cuttings will be generated using bentonite freshwater-based drilling fluid with zero oil. The well pad and cuttings management area were engineered to accommodate the anticipated volume of drill cuttings to be generated from the 23 wells. Due to the lower volume of drill cuttings generated per well in Plateau Valley, the design of the cuttings management area, and the size of the working pad surface, which can be utilized for remediation and treatment of the cuttings under an approved Form 27, Laramie does not believe a variance is necessary at this time. Laramie agrees to the COA language as presented by Ms. Treats this afternoon. Next slide. The Mesa County is a relevant local government of the Courier BCU, and there's no proximate local government. The Courier BCU is within the county's Agriculture, Forestry, and Transitional Zone District. Pursuant to ECMC Rule 302E, advance notice was sent to Mesa County's Community Development Department, notifying of Laramie's intentions to submit an OGDP. The notification detailed proposed operations and traffic projections. Mesa County requires an oil and gas location application for well pads within the subject zone district. Representatives from Mesa County's Community Development Department attended the on-site meeting on June 16, 2023. On June 18, 2023, Laramie submitted an oil and gas location application to Mesa County. As part of Mesa County's permit process, a public notice sign was posted for 15 days at the intersection of the existing lease road and the public road, Highway 330. This sign was visible to the public. Mesa County did not receive any comments during this period, and on July 25th, 2023, Mesa County issued the oil and gas location permit. Next slide. 3 federal wells will be drilled from the Courier BCU. In 2023, BLM attended a virtual pre-application meeting and an on-site meeting at the location. Both during the virtual meeting and the on-site visit, Laramie consulted with BLM regarding the design of the well pad and access road. Both entities discussed construction, stormwater control measures, and surface disturbance. Laramie submitted the 3 federal APD applications in July of 2023, approximately 16 days prior to submitting the OGDP to the ECMC. During the preparation of the environmental assessment, the BLM cited reduced staff was impacting APD timeframes and resulting in delays of review and processing federal permits. On July 17, 2024, the BLM provided an update stating the BLM was conducting the final review of the EA. Laramie has received positive feedback from the BLM and anticipates approval within the next month. Next slide. While the Courier BCU is not located within high priority habitat, there is one mapped habitat located within a 1-mile radius. CPW's mapped aquatic sports fish management waters exist upgrading and downgrading of the site. Physical barriers such as dense vegetation, existing lease roads, and varying topography exist between the Courier BCU and the sport fish management waters. As standard practice, Laramie always engages and consults with CPW early in the permitting process. CPW with ECMC staff attended a virtual OGDP pre-application meeting on May 25th, 2023. CPW also attended the on-site visit on June 12th, 2023. Next slide. In order to provide a comprehensive and detailed scope of the proposed development and potential sensitive receptors, Laramie always has an independent consultant conduct biological and environmental field surveys prior to on-site meetings. This allows Laramie to provide field verified data to CPW and other regulatory agencies during the on-site and gives opportunities for attendees to observe surrounding receptors. The biologist also attended the on-site and was available to answer questions from regulatory agencies. During the on-site meeting, CPW was able to observe the downgradient intermittent stream and ephemeral drainage, which are both located within 500 feet of the working pad surface. Laramie and CPW discussed best management practices to mitigate and minimize potential impacts. Laramie submitted a waiver request to CPW for Rule 1202A3. The waiver request detailed a list of BMPs, including emergency spill response trailer staged nearby during pre-production activities, an on-site spill kit during production phase, and remote monitoring and shut-in. CPW approved the waiver request on July 19th, 2023. Next slide. There are no RBUs within 2,000 feet of the Courier BCU working pad surface. No high occupancy buildings, school properties or facilities, child care centers, or designated outdoor activity areas are located within 1 mile of the proposed location. The nearest RBU is located 3,052 feet from the working pad surface. The photograph before you is in the direction of the RBUs. The RBUs are not visible from the proposed location as varying topography acts as a buffer, which I will discuss more over the next 2 slides. Next slide. As stated, the nearest RBU is located approximately 3,052 feet southeast from the Courier BCU. This elevation profile exhibits a varying topography between the RBU and Courier BCU. The RBU is located in a valley 200 feet below the site and is not visible from the location. Next slide. There are 2 RBUs located approximately 3,100 feet from the Courier BCU. The RBUs are located in a valley approximately 200 feet below the pad site. In addition, a ridge exists between the pad location and the RBUs as displayed in the elevation profile. Next slide. The Courier BCU is located within a disproportionately impacted community. As shown in the map before you, all of Eastern Mesa County is located within this DIC. This rural area is remote and consists of large agricultural parcels and public lands. The Courier BCU is located approximately 9.5 miles away from Colburn. The EnviroScan score is 19.3. ECMC staff contacted CDPHE of the OGDP passing completeness on November 17th, 2023, and CDPHE declined consultation. Next slide. This slide highlights some of the technology and practices Laramie will implement at the Courier BCU. During drilling, Laramie will utilize a closed-loop drilling system and freshwater-based drilling mud. During pre-production activities, temporary surface water lines will be used to transport fresh water. During completions and flowback, the Courier will tie into temporary and existing water lines for the transport of recycled produced water and flowback water. This will remove approximately 500 truck trips per well during completions and 200 truck trips for flowback. Utilizing water gathering lines in total will remove an estimated 16,000 truck trips. Existing water gathering lines will also reduce truck trips during production. At a minimum, during the first year of production operations, existing water lines will remove 3,200 truck trips from the road. Next slide. Laramie will implement numerous best managed practices to minimize and mitigate potential impacts, which best protects public health, the environment, safety, and wildlife resources. All the lighting will be shielded and directed downwards towards the working pad surface. Gas will be routed to a sales line at the first appearance of salable gas. And Laramie will install several stormwater control measures, including vehicle tracking, sediment traps, wattles, and a ditch and berm surrounding the perimeter of the pad. Next slide. Listed before you is a summary of our proposed air monitoring program. Laramie is currently preparing an air monitoring plan to submit to CDPHE. Next slide. This slide summarizes anticipated timeframes for operations at the Courier BCU. Laramie is planning 1 occupation for drilling activities. In this area with continuous operations, the average length of time to drill a well is 4.5 days and 1.5 days to complete a well. Next slide. Laramie's standard practice is to plan wells with a maximum inclination of 40 degrees or less, as shown in the figure to the right, to be vertical by the top of the producing formation in an S-curve directional design. The maximum reach from surface to bottom hole locations on the Courier BCU pad is about 3,500 feet. The top of the producing formation is around 6,050 feet true vertical depth for the Courier BCU. Based on Laramie's restrictions on hole angle, wells cannot exceed a horizontal distance of 3,500 feet from the surface hole location to the bottom hole location. Next slide. The Courier BCU does not trigger any of the alternative location analysis criteria listed under Rule 304B. Thus, an alternative location analysis was not prepared during the assessment of the mineral development. During the assessment of the mineral development in Section 16, Laramie evaluated 5 locations. When assessing suitable locations for development, Laramie always evaluates existing locations first in order to reduce potential surface disturbance. Laramie considered 2 producing well pads in the area, alternative location 1 and alternative location 2, to determine if either of these locations would be suitable. These 2 well pads were eliminated since all the targeted minerals could not be reached from these existing pads, and the producing pads were too small to accommodate proposed operations. The ability to expand these sites to accommodate an additional 23 wells is not feasible due to topographic restrictions, which would require increased surface disturbance for cut and fill slopes. Alternative location 4 was eliminated since the location was in 2,000 feet of an RBU. Laramie originally selected alternative location 3 due to several features, including all target minerals could be reached from this location, greater than 2,000 feet from an RBU, and proximity to existing private lease road and existing pipeline tie-in. However, a portion of alternative location 3 was located within a mapped aquatic high priority habitat, and in the summer of 2022, field surveys confirmed there was a wetlands feature within 500 feet. Since alternative location 3 would meet 2 ALA criteria listed under Rule 3042B, Laramie went back to the drawing board. Laramie identified the Courier BCU, the location presented before you today, and determined that this location would avoid sensitive receptors and minimize impacts. Even though considerable work had been completed for alternative location 3 and shifting locations would result in significant delays to permit application submittals, Laramie concluded that pursuing the Courier BCU was the best location and the location which was most protective of public health, safety, welfare, the environment, and wildlife resources. Laramie would like to thank ECMC for the alternative location process, which guided us in selecting the best possible location. And now I'll turn it over to Ms. Wazelinski to conclude Laramie's presentation.
Thank you, Ms. Middleton. Next slide, please. I'll just briefly conclude and summarize the Courier OGDP and request for approval. Mesa County supports the development and has approved a siting permit for this location. The proposed location does not trigger any ALA criteria. No petitions or public comments were submitted on the 2A. And finally, the siting and BMPs provide protection of public health, safety, welfare, the environment, and wildlife resources by avoiding, minimizing, and mitigating potential adverse impacts. And Laramie accepts all COAs listed in the director's recommendation as modified by Ms. Treats today. So with that, we respectfully request approval of the OGDP and associated Form 2A. This does conclude our presentation. We can go ahead and take the PowerPoint down, and we are open for questions.
Great. Thanks for taking the PowerPoint down. We are ready for questions from commissioners. Commissioner McGowan.
Thank you, Mr. Chair, and thank you for the presentation today, and hello to some of the West Oak folks that I know. I was wondering if, as part of the CPW consultation, there was a discussion of whether CPW would prefer that you use the existing location even though it was near a wetland because it had already been disturbed versus preferring you move further away.
Thank you for the question, Commissioner McGowan. Alternative location 3 was not is not an existing location, so it would have been new.
Oh, okay.
Only location 1 and 2 were existing pads.
Okay, thanks for clarifying that. I just wanted to talk a little bit about the conditions of approval related to soil sampling and drill cuttings and trenches, because I know that that's been a topic of discussion between our staff and West Slope operators and kind of the conditions that exist on the Western Slope, and sometimes it taking a little bit longer to address cuttings and soil sampling than you might see perhaps in the DJ Basin. And I just wanted to clarify kind of what I think I'm hearing is going to happen, which is there's going to be some kind of a little bit of cut and slope to build this location. A cuttings trench, which isn't really a trench, is going to be built next to the slope so that it will be part of remediation or reclaiming the cut slope and fill. And you all feel confident that you will be able to meet the requirements for having to handle the drill cuttings and meet soil sampling requirements within the conditions of approval that have been applied. I know that was a really long, but that was
Yeah,
my
that's-
understanding of what's happening. So
It's fine. Thanks, Commissioner McGowan. No, I think the other struggles like this one totally different from the upper higher elevation stuff we have. This one, we will be a lot further along and we'll be able to utilize a lot more space with the way the equipment layout is. We've took that into effect. With the approved 27, I don't see any problems of meeting those deadlines on this site.
okay, I just want to make sure that we're providing an opportunity. If you need a little longer runway, we could do it now and then not
Yeah. Appreciate it.
variance. Okay, thank you.
Other questions from commissioners? I'm having to flip back and forth between screens because we've got so many faces, but I'm not seeing further questions. Does any commissioner desire to start deliberations? Commissioner Messmer.
I was struggling to find my mute button. Sorry. I don't have any deliberations. I thought the presentation was very thorough. I appreciate it. I appreciate the application or the applicant working closely with staff and the consultants, and I think developed a very approvable application. And so with that, I'd move approval of docket number 2308000259.
Second.
Motion and a second. Commissioner Cross.
I just want to confirm that that's with the modified condition of approval.
That's correct.
Motion and a second modified relative to the COA. Any further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. All right, thank you very much to the panel. Thank you to the staff for helping put together their review of the docket. And with that, commissioners, we've concluded the matters on our agenda. I would look for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
We are adjourned. Thank you, everybody. Good work today.